I'm Reginald Lowe. I'd like to call the Panel B meeting to order. So I'd like to have Teresa call the roll.
Sure. Morning. Dr. Lowe?
Present.
Dr. Ganadev?
Present.
Dr. Levine? Present. Ms. Pines?
Here.
And Ms. Shipsky? Here. We have a quorum.
Thank you. So I'd like to go into closed session. So all those that are not supposed to be here, can we have you exit? And when you can come back when we have open session at about 11.
11. Yeah.
Looks like we're pretty close. Why don't we have the panel members introduce themselves? Why don't we start down here with Ms. Shipsky?
I'm Jerry Shipsky. I'm Denise Pines.
Sharon Levine.
Reginald Lowe.
Dave Ganadev.
Okay, are we ready? All the technical problems are good. Okay, so we're going to have an open session now with oral arguments on the non-adopted proposed decision on Ryan C. Peterson, MD, and I'll turn the proceedings over to Judge Yerke.
Thank you very much, Dr. Lowe. Good morning, ladies and gentlemen. My name is Amy Yerke. I'm an administrative law judge with the Office of Administrative Hearings. May I ask counsel to state their appearances on the record, please?
Good morning, Your Honor. John DeCure with the Office of the Attorney General.
Good morning, sir.
Good morning, Theodore Cohen for Dr. Peterson, who is seated here to my left.
Good morning, Mr. Cohen. Good morning, Dr. Peterson. I'm going to take a moment to call the case, and then I'll go over some ground rules for the proceeding this morning. So we're here in the matter of the accusation against Ryan C. Peterson. This is agency case number 06-2011-217874, Office of Administrative Hearings case number 2012-040825. Today is Thursday, April 25th. 2013. The time is approximately 11:30 in the morning, and we're located at the Hilton Hotel in Los Angeles, California. All right, so according to the procedures for the conduct of oral arguments, which can be found at California Code of Regulations, Title 16, Section 1364.30, the arguments that we hear today shall be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence may be heard. So there will come a time that the panel members will be invited to ask questions of either counsel or the respondent. And I'll just remind you folks that we can't ask any question that would elicit an answer that would bring us outside of the scope of the existing record. And so if I do hear a question that would call for that kind of answer, I'll just interrupt you and remind you that those questions are not permissible. Now, in terms of the timing for the arguments, again, pursuant to this statute, the respondent's attorney will go first, and sir, you'll be limited to 15 minutes. Then Mr. DeCure, you'll also receive 15 minutes. Then we'll turn back again to Mr. Cohen, and you'll have an additional 5 minutes. And then Mr. DeCure, you'll also get another 5 minutes. And then after that, Dr. Peterson, if there's anything that you'd like to say, you'll be given an opportunity to do that. And if you choose to make a statement, then I'll put you under oath at that time. All right. So we'll begin. Mr. Cohen, would you like to begin the proceeding?
Thank you very much. Is it okay if I stand maybe?
Yes, sir.
Try. It's a pleasure to be here today, and nice to see Mr. DeCure after many years. I think one of these days we're going to do away with lawyers and have the doctor just sit with the panel, you physicians and other public health members and I think after talking to him for about an hour, you're going to know a lot more about him than can come out during a trial. But that's maybe something in the future. So right now, Mr. DeCure and I are still working. During Governor Brown's original term as governor many years ago, I had the privilege of serving as a public member on the Physicians Diversion Program, which the Medical Board had established in 1980, and I did that for about 10 years, and I had the joy of seeing hundreds and hundreds of physicians who were suffering from the disease of chemical dependency come back and restore their lives and be able to serve their profession and the public once again. So I think it's fitting that the profession that is dedicated to alleviating the ills of mankind be in the forefront of helping those of its own who are suffering from this disease that they acquire through no fault of their own, because as we know in all the professions, chemical dependency is now classified as a disease. One doesn't wish to get it, and Dr. Peterson didn't wish to get it. So I think that in addition to showing the public that your mission is to protect the public, I think it's also would be important that in doing so and in carrying out that mission, that the public be made aware, and the profession is making the public aware, that people and physicians can and do recover from the disease of chemical dependency, and some recover more slowly and some recover more quickly. And I think we have a situation here with Dr. Peterson where the evidence, I don't like to use terms like overwhelming, I think the evidence was really, really credible. I wish that all of you could have been there at the hearings to hear these medical professionals and psychiatric and psychological professionals testify about Dr. Peterson's recovery. It was a stellar recovery. They said he was in the 1%. If they had to rate people in a percentage of their recovery, they would rate him as 1%. He entered into a strict, severe program of recovery, and he is, this next week, he will have 20 months of sobriety, clean and sober, 20 months since this all began. When this first happened, he immediately agreed with the Attorney General's office to surrender his license, that he wouldn't be practicing. He didn't fight the board in any way. He agreed with everything that the board wanted him to do. And he sits before you today as a physician in recovery. We have here in the audience Jim Conway, a psychologist who has worked treating physicians since the 1980s, running the groups of physicians in recovery. And Dr. Kelly, who is seated in back of me. Dr. Kelly was his employer in an anesthesiology practice, and the evidence was, and Dr. Kelly testified at the hearing, that he wants to hire him back. He's aware of his situation. He will be monitored. Dr. Peterson is undergoing propofol, I have trouble with this word, propofol glucuronamide urine test. That's a new test. They didn't have that test earlier. This is a brand new test now. And people were concerned about anesthesiologists going back into practice. And I'm happy that everybody here seems to have agreed, and that the board seems to have agreed, that Dr. Peterson is fit to go back to the practice of medicine. The only issue here today, as I understand it, is whether he should be permitted to practice his specialty of anesthesiology. And so he is now undergoing rigorous treatment. He's engaged in 12-step programs. He's taking this propofol glucuronamide, am I pronouncing it correct, doctor? The urine test, and he's on Vivitrol, which blocks the opiate receptors. And we had Dr. Skipper, who was a renowned physician who ran the Alabama program for many, many years, the physicians program for the Alabama Medical Board, and who did many, many studies and published many studies about anesthesiologists, because the issue is, should a physician, even though he can keep his or her license, be permitted to go back to doing anesthesiology? And the record is clear that Dr. Skipper's research and published works showed that anesthesiologists are quite safe to go back to the practice of anesthesiology. He said, I think that the studies that I put forward here, that anesthesiologists can go back to work as anesthesiologists, they don't harm patients. As long as they are monitored properly, they do well. And so Dr. Skipper's publications and all the research indicates that anesthesiologists should not and need not be singled out to be restricted from practicing anesthesiology when they are recovering from the disease of chemical dependency. We also have, I think, an important letter, and it's Exhibit B in the documents that we filed, from Dr. Hartunian, who did not testify at the hearings, but he did submit an affidavit. And Dr. Hartunian, Harry Hartunian, is the director of the Physicians Recovery Program, I don't know if that's the right term for it, at the renowned Betty Ford Center in Rancho Mirage, California. Dr. Hartunian said that he worked with hundreds and hundreds of physicians, both in interventions and in treatment. And he has observed Dr. Peterson closely and intimately. And Dr. Peterson goes out there regularly to the Betty Ford Center to share his recovery experience with other physicians who are newly in recovery. This man gives to people. He is not selfish about his recovery. He shares it with others. And Dr. Hartunian believes, and he has written his affidavit, which we've attached, that Dr. Peterson is capable and competent to go back to the practice of anesthesiology. So I submit to you, the board, that we have Dr. Hartunian, who has monitored hundreds and hundreds of physicians at the Betty Ford Center, who feels he could go back to anesthesiology. Dr. Skipper, Jim Conway, and all of these experts that testified at the hearing. And then we have his employer, Dr. Kelly. I believe that that gives you and the public an assurance that Dr. Peterson is going to be monitored, he's going to be watched, he's going to be looked after. Dr. Kelly has a large practice where they furnish anesthesiologists to, I believe, 15 different surgery centers in the Los Angeles area. Dr. Kelly knows Dr. Peterson intimately. He's watched him. He's watched his recovery. He is willing to risk his business, his license, his reputation to hire Dr. Peterson back if you will allow Dr. Peterson to go back to the practice of anesthesiology. And I think that is your guarantee that the public safety is going to be looked after. The fact that Dr. Kelly, his employer, has a lot to lose if Dr. Peterson did not practice competently and adequately, and Dr. Kelly is willing to hire him, take a chance on him, give him employment, and be his monitor. That is the assurance, I believe, that the public needs to know that Dr. Peterson is competent to go back to practicing anesthesiology, and I hope that that is what the board will do. Thank you.
Thank you, sir. Mr. DeCure.
Thank you. Good morning, everyone. I want to start by taking you back a little bit to the proposed decision, because I think that it would be better for you to have the full context of the situation before you when you begin to consider, well, what do we do with this case? I know that's why the decision was not adopted. The question is, what should the end result be? And before I get into discussing that, I want to remind you of a few things that were factual findings that were not disputed, and certainly the respondent deserves credit for admitting to this history, but I'm going to highlight this history for you so that you have a full context of the drug addiction we're talking about. Paragraph 5 in the decision lists that in the summer of 2000, this is nearly 13 years ago, the respondent began using methamphetamine, crystal meth, and GHB, often referred to as the date rape drug. He used the GHB to counter the speed-inducing effect of methamphetamine. So this is nearly 13 years ago, the beginning of this drug use. A medical doctor who knows the effect of drugs, and he is now using two different drugs that have contradictory effects. Starting in 2005, he began to use Xanax, an anti-anxiety medication, to achieve the same results as the GHB. He reports that that was recreational. He continued to periodically use these two substances throughout med school, during his residency and fellowship. Paragraph 6 states that his first employment in June of 2009 until October 2010 was concluded when he was fired from his job after it was discovered that he diverted drugs for his personal use. In October of 2010, he was with a new group, KJD, which provided anesthesiologists on like a subcontractor basis. His meth use increased in 2010. He was now ingesting it intravenously and had 2 to 3 binges per month. He started using fentanyl, a synthetic opiate, to come down from the meth binges. His tolerance for fentanyl increased, and from May through November of 2010, he was injecting 1,000 micrograms daily. In spring of 2011, he was injecting 100 to 200 micrograms of fentanyl 2 or 3 times per week, even when not binging on meth. He occasionally used Ambien or other benzodiazepines to come down from meth binges. By May of 2011, he self-injected propofol. He used it to take away the anxiety of methamphetamine. Did so on multiple occasions over the following 13 days. This was from May 1st of 2011. Repeatedly injected it after work. He was involved in 3 car accidents over a 4-day period while under the influence of propofol. May 13 of 2011, he injected propofol, quote, while working at the Encino Plaza Surgical Center during a lunch break between the morning surgery and the afternoon procedure. He administered anesthesia to 1 patient after having injected the propofol, end quote. At this point, he realized he'd gone over the line. He sought treatment. He went back to work in August of 2011, and in paragraph 18, it was found that he was using fentanyl and propofol at home after work. He wanted to take a couple of weeks off of his recovery. August 26, 2011, a nurse reported seeing needle marks on him. He was suspended from work. On August 29, 2011, this is paragraph 19, he went into a surgery center and stole 2 50-milliliter bottles of propofol. He went home and injected the entire quantity over the next few hours. These are all factual findings, and this is the original context from which your discipline will come. It's conceded by the medical board, I think, very reasonably. It's conceded by the complainant, that is, who I represent, that the respondent has done a good deal toward getting better. The problem is, you've got a question of, well, what do we do? Do we allow him to immediately go back to practice in anesthesia, where he will be surrounded by powerful drugs, where he has had a history of struggling, where he admittedly got treatment and came back to work in anesthesia and found the situation to be overwhelming? Keep in mind that since that time that the respondent had his relapse, he had first-rate treatment. He went to Hazelden, he went to Betty Ford, he came back and he sought support groups here, and some of the people from those from that treatment he was lining up are here today. So he was doing all the right things, but when he went back to work, it became too much, and that happened very quickly. You have to look at the time frame involved in any drug or alcohol addiction case, because you're talking about really a track record that an addict, a confirmed addict, needs to show of sobriety, of good decision making, of a stable life, and so forth. And the only thing that you can rely upon is time. One of the, I noted in my argument that one of the respondents' witnesses, Dr. Tarrington, testified As to whether or not relapses were possible or should be expected, the answer he gave was absolutely. And we did have a relapse immediately when the respondent went back to work. Another important issue involving anesthesia practice was also addressed at trial, and that had to do with whether there would be safeguards to make sure that in such a critically important role as administering anesthesia, I know you all know what that involves. That's really life and death stuff. Would he have safeguards in place to ensure that if there were a relapse, somebody would not die on an operating table? The answer is, well, yes and no. There are cameras, there's technology involving dispensing of drugs that can track how much drugs the anesthesiologist is receiving to administer to the patient and so on. But this is all fairly sophisticated, it's expensive equipment, and when asked whether these kinds of safeguards would be in place in the smaller surgical centers where the respondent would be practicing anesthesia, the answer was no, it's not likely. They would not have that kind of equipment. I think most importantly for this panel, you have to consider that we're not talking about punishment. We're talking about public protection. The board very reasonably is, or the complainant is, I believe, very reasonably suggesting not that his medical career be ended, but that the revocation of his license be stayed. The 7 years of probation is a lengthy term, certainly long enough for many years of monitoring, and God willing, the respondent will go through the entire 7-year period clean and sober, and his business with the medical board will be finished once and for all. We all hope that that will happen. But for right now, he has 20 months under his belt. He has been suspended under an interim suspension order since October of 2011. In other words, he has not yet gone back to that medical workplace where those tremendous pressures await. Not only is anesthesia difficult, it's high risk, it's very involved, it brings with it intense pressure at times, and there would be even more pressure being in a setting in which the respondent has failed before. That is why I'm recommending on behalf of the complainant that the respondent, I believe all the orders are correct, except for his ability to return with no restrictions to the practice of anesthesia. That should be withheld. He should be suspended from practicing anesthesia for another 3 years. That'll give him nearly 5 years of a clean track record. I don't believe that the public should be bearing the risk of a relapse or bearing the risk that this return to a high-pressure situation will be too soon and could be calamitous. Thank you.
Thank you, Mr. DeCure. Mr. Cohen?
I'll just take a moment, and then Dr. Peterson's here to answer any questions you might have of him. I think that in the field of science, that it's not entirely appropriate to just set a time when people are deemed recovered. Should we say that everyone has to wait 5 years? We know that with all illnesses, and you physicians know this better than anyone, some people recover very quickly. Some people go into remission. Some people do not recover. So I think that as scientists, it is inappropriate to just say that someone should wait 5 years before they could practice anesthesia again. All of the studies by Dr. Skipper, which are set forth in his testimony and which came into evidence, indicate that people can go back to the practice of anesthesia just like they can go back to the practice in other fields of medicine. And I agree with counsel that the conditions set forth by the learned administrative law judge, who found that he should be able to go back to anesthesia, are appropriate. Perhaps the board would want him to be examined at this time. In other words, what I'm saying is we don't know when a person should or shouldn't be able to go back to their specialty again. He has not been examined recently. Perhaps the board would want him to be examined right at this moment by someone appointed by the board to see whether he can safely go back to practice anesthesia. And he is available to do that. I just want to make one more comment. Counsel pointed out in the Attorney General's brief about the thought that because Dr. Peterson attended and attends 2 AA meetings a day, that might indicate that he's fragile in his sobriety. And I submit to you that doesn't indicate that anyone is fragile if they're attending 2 meetings a day. What it means is that they're dedicated to their sobriety, that they're willing to put their sobriety ahead of everything, and they're willing to share their experience at meetings of Alcoholics Anonymous and Narcotics Anonymous with other people who are new in recovery. So the fact that he attends a lot of AA meetings and that he's in a lot of therapy doesn't mean he's at risk. What it means is that he's dedicated to his recovery, and he has made that a priority in his life. And he's right here with you, answer any questions you might have. Thank you.
All right, thank you. Mr. DeCure?
Very briefly, I think you can characterize the recovery efforts that the respondents made as being commendable, yet just the same, they are very intense. And that is because of the context I reminded you of. This is a long-term drug problem. This is a long-term history, and it involved a high level of intelligence on behalf of the respondent and an ability to be able to mix drugs to achieve a certain effect. And again, anesthesia takes Dr. Peterson right back to that medical setting in which those drugs are present and available, and it is too soon. I submit to you that you have to, when you decide what to do, you've got to use your best judgment. We don't have answers, Mr. Cohen's correct, as to how many years, how many weeks, and how many days it is before someone's cured. I think Dr. Peterson probably would agree with the statement that if you are an addict or an alcoholic and you're in recovery, you still struggle with that recovery every day, in that you have to take one day at a time. I can't give you an answer, but I can tell you that 3 years would give him a lengthy term of sobriety. He has been clean and sober for 20 months. It's not very long. He went back to work once and immediately relapsed. That should be cause for real concern. That work was not reading slides in a pathology lab. It was not doing ear, nose, and throat medicine, seeing a few patients a day. It was the pressure cooker of being an anesthesiologist and putting people under during surgeries. It is not a good mix. Thank you.
Thank you, Mr. DeCure. Dr. Peterson, would you like to make a statement?
Sure.
All right, I'm going to swear you in. Please raise your right hand. Do you swear or affirm that the testimony you are about to give will be the truth and the whole truth, so help you God?
I do.
Okay, thank you. You may be seated if you're more comfortable. And if I could ask you to pull the microphone in front of you, please. Thank you.
Hi, thank you. I really don't have anything planned to say. I just, in the context of the conversation, and I really appreciated what Mr. DeCure said about how addiction is treated on a daily basis. I came from a really ugly place back then, and it's, I read this about me, and it's all true, and I have verified that at the hearing that this is what happened. I take responsibility for that, and I'm remorseful for it. It's just so ugly. I'm so grateful that there was something available to me that worked, a treatment that worked. Addiction is treated one day at a time, and my sobriety today is not the same as my sobriety tomorrow or yesterday. But I do have the willingness each day to wake up and do what it takes to stay sober, and that won't change if I go back to anesthesiology. I really love anesthesiology. I think that it's a career that I would have chosen all over again, even knowing what's happened to me. Luckily, there's a lot of safeguards that I can put into place. You know, this propofol glucuronide urine testing is so good. I can do that every week, and it tests for the metabolites of propofol. If any propofol was consumed in the last 5 days, it'll pick it up. Same goes for all the other drugs that I've abused, and so there's a lot of accountability that I can set up if I go back to anesthesia, if you are willing. One final thing is that I just want to make the comment that you know, this has the treatment that I do on a daily basis to stay sober from drugs and alcohol. It doesn't feel like a burden to me. This is something I've grown to enjoy. I've worked it into the very core of my existence, and I love it. And you know, that to me is the greatest gift I've ever been given. Not that I could get sober, but that I found something so good about sobriety that I want to keep it. And so with that, I will close. Thank you. Thank you for your time.
Thank you, sir. Do any of the panel members have questions? I'll start on my left with Dr. Lowe.
Ganadev. Thank you, George. Dr. Peterson, we're thrilled that nobody got hurt. That is, there was no public harm. But what guarantee is there when you go back to anesthesia? I understand you're going through all rehab, and unfortunately you did relapse, which is not uncommon with addiction. Why do you want to go back to anesthesia so soon, which you had a problem already with a potential public harm which is serious both for you and to the public?
Before you answer that, I just need to remind everyone that we're bound by the evidence in this proceeding, so to the extent that your answer would go beyond something that's outside of what's already been presented, unfortunately, I can't have you bring that information in.
Okay, I will keep that in mind. Thank you. I want to clarify that when that relapse happened after I went back to work, I was a different person then, and I went back, every addict needs to have, I guess, a rock bottom. And that, even though it was only 4 days long, that relapse, before I bounced back to Betty Ford for another inpatient treatment session, I didn't work the recovery program then that I work now. It took that awful experience for me to have the willingness and the open-mindedness to surrender to a completely new way of thinking and a new way of living my life. And so, unfortunately, I'm so glad that nobody got hurt. I'm so glad that no patient or nobody on the road or myself, I'm so glad that nobody got hurt and there were no complaints of anything. But I wanna, it's hard for me to do this myself. It's easier when people, who treat me say it for me, but I'm really different now. And that's because of 20 months of looking back on this devastating experience, having the door be open to a new way of living, and taking that treatment one day at a time and really working it into my life. So in terms of going back to anesthesia, yes, it's a stressful career. It's anesthesiologists are under stress. I've had a lot of stress, and in these past 20 months as well. I believe that if I continue to work the same program that I worked for the last 20 months, when I go back to work, I will be more than successful. There are urine, hair, nail testing, and people that I see every day that that add a safeguard of accountability. But my primary focus is on the spiritual program that has changed my life since that relapse. It's just, things are so much different now.
Any further questions from you? All right, Dr. Lowe, anything?
Well, I commend you on your recovery, and I'm curious if you were able to go back to practice as an anesthesiologist with that very busy schedule, how would that impact your ability to participate in these programs that are continuing to keep you healthy?
That's something I've given a lot of thought to, and I appreciate that question. You know, one wonderful thing about our Dr. Kelly's practice is that, you know, we're working in surgery centers. It's not a hospital-based nights, weekends, call type of thing. You know, and also living in Los Angeles, there's meetings happening every hour, almost, well, not in the middle of the night, but, you know, going till 1 a.m., there are meetings. And so, like I said before, you know, my priority is my sobriety. It will never become my career, because I know that whatever I put in front of my sobriety, I will lose. And that could be interpersonal relationships, it could be career, it could be job. Whatever I put in front of my sobriety, I will lose. And I understand that really to my core. And so, for example, I get out of work at 2 p.m., I know where the 3 o'clock meeting is, and I already go to the 7 o'clock meeting that day. My therapist has already agreed to see me on Saturdays. You know, I am in urine testing, which is I will always do after work. You know, I will keep. You know, again, it's not a burden for me. The stuff I will do to stay sober is stuff I want to do. You know, a lot of people want to go run with their dog after work, and for me, I want to go to a meeting. It really is it's a big part of my life. So
I appreciate that answer. I have one other question, and that relates to the opioid blocker. Is this something you feel like is an important part of your recovery and the need for continued use of an opioid blocker?
Yeah, well, okay, so Vivitrol is an opiate blocker that is injected into the muscle by my doctor, by my addiction medicine doctor, once a month. And that it doesn't prevent me from relapsing. You know, what the spiritual program that I've alluded to is what prevents me from relapsing. But what that drug does is that if there's a relapse on opiates, the drug bounces off the receptor, I become unimpaired, I remain unimpaired, and the drug goes into my urine where it will be picked up, and I will undergo consequences very quickly, or into my hair or nails or whatnot. Do I look at Vivitrol as a primary thing that's keeping me sober? No, I see it as an adjunct. I see it as a safeguard. I will continue to do it. I'm glad the drug exists, and I will probably stay on it for a long time, much longer than the board would require me to at this point, because I get no side effects from it, and it's an easy thing to do once a month. I hope that answers your question. It's not a primary thing for me.
Okay, thank you very much. I have no further questions.
Dr. Levine?
No questions, thank you.
Ms. Pines? No. And Ms. Shipsky? Questions? All right. Well, then at this time, I want to say thank you to everyone. We'll go off the record, and I'm going to ask the members of the audience if you could please vacate the room, and the panel will adjourn into closed session.
Okay, the mics are on. Good afternoon. I apologize for the slight delay, but the earlier sessions had gone over. And I'm Reginald Lowe, and I'd like to call to order the Enforcement Committee of the Medical Board of California. Renee, can we have the roll call, please?
Yes. Good afternoon.
Oh, Teresa is going to do it, I guess.
Hi. Dr. Gonadev?
Here.
Dr. Levine?
Here.
Mr. Serrano-Sewell?
Here.
Ms. Shipsky? Ms. Yaroslavsky? And Dr. Lowe?
Here.
We have a quorum.
Okay, maybe you can help round up the other two.
Okay, I know we're still in, well, I'll find.
Can we do that?
Ms. Shipsky should not be.
Okay, so we will now take public comment on items not listed on the agenda. Speaker slips are available in the back of the room. If you would like to speak, please hand them to either Teresa or Ms. Threadgill. For those who want to speak on items that are on the agenda, please go ahead and fill out the speaker slip, and you will be called after each specific agenda item is raised. Okay, so we have one public comment from Genevieve Carrul. So we're going to limit, oh, there's another one as well. So we're going to limit comments to 3 minutes. Okay.
Good afternoon, Medical Board. Geneviève Claverol. I want to bring an issue to your attention. On March 6th of this year, my daughter went to see someone who was identified themselves as a psychiatrist for an organization named Winston Behavioral Health. My daughter, who is 50 years old, was with that so-called physician for less than 15 minutes, was not given any test or whatever, was told that, have you ever been diagnosed as bipolar? And at which point my daughter told that individual, you know, my mother is an RN, and she was teaching psychiatric nursing. I think if I had bipolar, she would have identified me as so. At this point, that individual never said, you know, oh, I am also an RN. I think that would have been a good clue. At the end of the 15 minutes, she told my daughter, I think maybe you should be hospitalized, and prescribe her 2 drugs for, you know, bipolar, Lamictal and Celexa, never telling my daughter how to take those medications. When my daughter came back to see me in the lobby, and I read the prescription pad, this individual is not a physician. She's a nurse practitioner. You know, I have nothing against nurse practitioner, but I surely have something about misrepresentation. Specifically, when someone pretends to be a physician, label my daughter with less than 15 minutes at being bipolar, give her prescription who are pretty significant, and not give her a reason why she was going to have to take that medication and how should we take it. The name of that individual is Yvonne Estrada Bazan. I have already filed a complaint with the Board of Nursing as a misrepresentation of the facts. And I think she was practicing medicine without a license, and I would like some action being taken.
Okay, thank you for your comments. Okay, so we have another public comment from Alicia Cole.
Hi.
Good afternoon.
Good afternoon. Thank you for allowing me the opportunity to speak and to be here today. My name is Alicia Cole, and I am an activist and a survivor. I am with the California Safe Patient Project, which is a division of Consumers Union. We are the California Safe Patient Network, and I want to speak to you today about an issue that is not on the agenda today, but I feel that it is one of great importance for the public and for the safety of the citizens of California, and that is an issue related to posting malpractice settlements and judgments on the California Department of Public Health website. I myself, I'm a survivor of necrotizing fasciitis, commonly known to the public as flesh-eating disease. I acquired necrotizing fasciitis, sepsis, Pseudomonas, VRE, and MRSA during a routine procedure to have 2 uterine fibroids removed. I left the operating room with a fever, nausea, vomiting, and from there, my 2-day hospital stay turned into 2 months, a month in the ICU, 6 additional surgeries, almost having my left leg amputated, 5 months of everyday hyperbaric oxygen chamber treatments, a year and 2 months of twice-a-day home health care nursing, 3 years with an open, draining abdomen, and for the last 6 years, including now, I am still in physical therapy and pelvic floor rehabilitation. I have on a heating patch and a back brace as we speak to get through this meeting. The highlight of my hospital stay was having my doctor do a bedside procedure, cutting me open in my hospital bed without anesthesia, without wiping my stomach or cleaning it, and asking my mother to assist him when the nurse did not come back to the room. I've since learned that I was my doctor's 3rd encounter with necrotizing fasciitis, and he's had a patient with necrotizing fasciitis after me. If you look at the medical board's website, he has no settlements and no judgments against him. If you go to the Burbank courthouse, you will find that there are 8 cases against him. And I know of 2 personally that have settled for over $30,000. Now, according to the Business and Professional Code, Section 2001.1, the medical board's highest policy priority is to protect the public. One of the most important ways that we feel that the medical board can accurately protect the public is by displaying their malpractice judgments and settlements and disciplinary history. This allows the consumers of California to be better informed about the choices that they make when they're entrusting their life and their livelihood to a physician. A November 2008 report by the California Research Bureau to the medical board stated that disciplinary and citation histories of at least 10 years are useful for forecasting the likelihood of future disciplinary actions against a physician. And additionally, their research showed that malpractice payout histories and settlements reported to the medical board, whether or not these were disclosed to the public, are directly predictive of future disciplinary actions for 5 years and indirectly predictive for a longer period of time. And that is from a report that was received by the medical board in 2008.
Thank you for your
Yep.
comments. I think your time is up.
I thank you for your time, and I hope that you would please take that into consideration.
We appreciate your comments. Okay, are there any additional public comments not on, for things not on the agenda? Okay, with none, then we'll move on to the approval of the minutes from January 31st, 2013. Is there a motion to approve these minutes?
So moved.
Do we have a second?
Second.
We have a motion and a second. Is there any public comment, discussion? All those in favor of approving the minutes, please say aye.
Aye.
Any opposed? Abstentions? Minutes are approved. Okay, so we're going to take things in a slightly different sequence. We've been requested to change the order of the agenda items. We're going to take number 10, is it number 10? Item number 10 next. And item 10 is a discussion of the Medical Board of California's efforts to implement SB 1441, which is uniform standards. Can we have Ms. Katie up to make those comments? I mean, to give the presentation, please?
Thank you.
Okay, Ms. Katie, thank you.
Good afternoon, committee. For the benefit of some of the newer members of the board, I would like to start this discussion with some background on the uniform standards related to substance abusing licensees. SB 1441 required the establishment of a Substance Abuse Coordination Committee under the Department of Consumer Affairs, which consisted of executive officers from the Healing Arts Boards. The committee was tasked with formulating uniform and specific standards in 16 identified areas that each Healing Arts Board shall use in dealing with substance abusing physicians. The board began the process of updating the regulations containing the current model disciplinary guidelines in 2009, and the majority of the changes incorporated in this edition were discussed and vetted in 2009. During that same period of time, the Substance Abuse Coordination Committee started drafting the uniform standards. The first set of uniform standards was adopted by the committee in April 2010. In August, the board opted to withdraw the regulation package and start the rulemaking process again. A public hearing was held in November 2010 with the intent of moving forward with the updated disciplinary guidelines. In response to public comments raised at that meeting, the board scheduled an interested parties meeting in January 2011 to take public comment and consider any additional changes that might be needed. On January 28, 2011, the board voted to adopt the regulations containing the disciplinary guidelines after addressing issues raised at the interested parties meeting. The board's regulation package moved forward and was approved by the Office of Administrative Law in December 2011. Just a little more background on the diversion program. The diversion program was established as a monitoring program that allowed physicians impaired due to substance abuse a pathway to be diverted from disciplinary action. As part of the intake process, participants signed contracts with the board requiring that they adhere to conditions such as a clinical evaluation to identify an appropriate treatment program, and aftercare, which included individual group therapy sessions, AA meetings, worksite monitors, and random biological fluid testing. Staff in the diversion program were responsible for monitoring physicians to ensure that they were complying with the terms of their contract. In 2008, the board allowed the diversion program to be sunsetted because multiple audits had found that physicians with substance abuse issues were not being adequately monitored. The policy decision made by the board was that physicians would be solely responsible for their own treatment and recovery from substance abuse. Through the probation monitoring unit, the board would only monitor the physician's fitness for practice and compliance with the abstain from use requirements through the biological fluid testing. One of the major criticisms raised at the last meeting was the assertion that some of the uniform standards did not apply to the medical board because the board no longer had a diversion program. In retrospect, the use of the term not applicable was a poor choice of words. The Department of Consumer Affairs has sought several legal opinions on the issue of whether the use of uniform standards was discretionary. The legal opinions all indicate that Healing Arts Boards must use the uniform standards when it undertakes an action covered by the standard. In other words, if the board orders a licensee to undergo a clinical diagnostic evaluation, the criteria set forth in Uniform Standard Number 1 must apply. When updating the disciplinary guidelines in 2011, staff focused on incorporating the requirements from the uniform standards into the conditions that the board would order for a physician with a substance abuse issue. Because the board does not order a physician to undergo a clinical diagnostic evaluation or enter into a treatment program or attend group support meetings, those standards were not addressed in the board's disciplinary guidelines. It's unclear whether the board could demonstrate to the Office of Administrative Law the necessity for standards relating to diversion program requirements in the absence of a diversion program. And we believe that maybe further legal analysis is required to answer that question. The main conditions that are ordered by the board for physicians with substance abuse issues are the requirements to abstain from the use of drugs and alcohol, biological fluid testing, a psychiatric evaluation and psychotherapy, and/or medical treatment. I'd briefly like to review each of the standards that have been implemented by the board, either by incorporating the requirement into the disciplinary guidelines or through probation unit policy. Uniform Standard Number 3 identifies requirements that allow the licensing board to communicate with the licensee's employer about the licensee's status or condition. The probation unit currently requires the physicians to complete a quarterly declaration, which identifies the clinic name, the address, the work schedule for any locations that a physician practices in. Contact information for the medical director or chief of staff must also be provided. Employer information is also confirmed verbally during each quarterly interview with the physician. The probation unit can develop a release to be signed by the physician in order to allow them to communicate more freely with the employer as needed. Uniform Standard Number 4 identifies the requirements for all aspects of the required biological fluid testing, including testing frequency and the standards for testing locations. This uniform standard was controversial primarily because of the differing opinions and discussion related to the required testing frequency. The uniform standard initially proposed that all licensees be required to test 104 times per year during the first year of probation. The board's existing disciplinary guideline required that physicians be tested a minimum of 48 times per year, and the board's current guidelines do not identify specific testing frequency. The lack of specificity was by design in order to give the board greater flexibility in scheduling biological fluid testing as needed. In 2011, the board was involved in defending a writ of mandate filed by a physician who was challenging the testing frequency that was contained in his disciplinary order. Testing frequency was discussed at the hearing in January 2011, and Ms. Whitney noted that there was no agreement on this issue amongst the Substance Abuse Committee members because there was no evidence-based information to support requiring 104 tests per year. The committee was scheduled to revisit this issue, but over a year had passed without it being addressed. So MBC went forward with the proposed language that did not contain a specific testing frequency so that the testing frequency could be established by policy once the uniform standard was finalized by the committee. In April 2011, the committee revised the uniform standard to the current testing frequency of 52 times to 104 times per year during the first year of monitoring. The probation unit uses this testing frequency as the standard for physicians with biological fluid testing requirements. Uniform Standard Number 4 also contains specific requirements for specimen collectors, collection sites, and response times for lab results. The probation unit has established a contract with First Lab to perform the biological fluid testing requirements contained in Uniform Standard Number 4. The requirements of the contract include all of the requirements that have been incorporated into Uniform Standard Number 4. It should also be noted that other healing arts boards also utilize a contracted vendor to perform biological fluid testing and fulfill the requirements of this uniform standard. Is that one 8? Okay. Uniform Standard Number 8 and 9 identifies procedures to be followed when a licensee tests positive for a banned substance. This uniform standard requires the board to issue a cease practice order, contact the licensee and advise them to leave work, and notify the employer that the licensee may not work. After notifications are made, then the board must determine whether the positive test was in fact evidence of prohibited use. If so, then Uniform Standard Number 9 applies and identifies the confirmed result as a major violation. The penalties for committing a major violation are then spelled out in Uniform Standard Number 10. The board updated the language in the disciplinary guidelines to allow the issuance of a cease practice order in order to conform to this standard. At the interested parties meeting, CMA expressed strong concern that imposing a cease practice order or an automatic suspension without affording the licensee due process could be considered unconstitutional and may violate the 14th Amendment. In response to this concern, the board added language to specify that an accusation must be filed within 15 days or a cease practice order would cease or would lapse. The amendment provided the licensees with a mechanism for due process, but still allowed the board to remove the physician from practice as the uniform standard required. Finally, Uniform Standard Number 10. Uniform Standard Number 10 identifies actions that the board will take for minor and major violations. It's the board's current policy to proceed with administrative action for any substantiated violation of the terms and conditions of probation, particularly those that relate to fitness for practice or failing to comply with an order for a medical or psychiatric evaluation or testing positive for a banned substance. At the time the regulations containing the disciplinary guidelines were being vetted through the rulemaking process, the uniform standards were still being discussed and finalized. We recognize that there are amendments that need to be made to the board's disciplinary guidelines in order to more fully incorporate the uniform standards. For example, the board does need to define a trigger which would identify a licensee as substance abusing in order to prompt the imposition of a mandatory conditions that are ordered under the uniform standards. The board also needs to provide direction to the ALJs and the AG's office that they have no ability to modify the relevant conditions in the uniform standards for physicians identified as substance abusing. There is still much discussion amongst the healing arts boards about how best to incorporate the uniform standards into regulation. There are 18 healing arts boards that are required to implement these uniform standards. The Department of Consumer Affairs has identified that only 4 boards have adopted the standards through regulation. The 4 boards that are identified as being in compliance are the Board of Occupational Therapy, the Optometry Board, Vocational Nurse, and the Respiratory Care Board. None of these boards have diversion programs. Only 1 board has incorporated verbatim all of the language from the uniform standards into regulation. The remaining boards have either modified the language or incorporated standards, or have modified or not incorporated standards that were specific to diversion program requirements. The larger healing arts boards who have diversion programs, such as Board of Pharmacy, Dental Board, Veterinary Medicine, have not incorporated the standards into regulation or into their disciplinary guidelines. Staff is proposing that we return to this committee with some recommendations for any modifications needed to the disciplinary guidelines to implement components of DCA's uniform standards that have not previously been addressed. Question?
Okay, thank you for that very thorough discussion. Do we have comments from the board members? Yes, Mr. Sewell.
Dr. Lowe, thank you. So, very good presentation. Thank you. And I've in this issue and discussion. All right, there we go. I've had a chance to take another look at SB 1441, the legal opinions that are floating around, trying to grapple with what may be some outstanding legal issues. The board's actions, most recently at the last enforcement meeting, which I thought that this committee was pretty clear about what it wanted to do. So, I mean, at this stage, I'm of the mind that the board, through this committee, ought to adopt all the standards and begin the rulemaking process. And so, and it's through that rulemaking, notice and comment period that we can fashion the regulations, assign them to the right parts of our jurisdiction and just sort of move on. This has just, in my mind, been an ongoing issue. I think the best thing to do is to adopt the remaining standards that we have not adopted, recognizing, as your report notes, that it does present some challenges. But that's either here nor there. I mean, we'll deal with it. As to what other healing arts boards and commissions do, that's up to them. You know, I'm on the medical board, so I'm concerned about what we do. And I just have a very strong desire to just bring closure to this issue, not prolonging it any further. And the first thing to do is, in my mind, to answer your question, or a question that you raised in the report, how do we implement it? Well, by adopting them and then commencing the rulemaking process. And we'll see where that leads us. And I'd rather, it's my preference is to go on record as soon as possible as a full board, adopting all the standards, all of them, and leaving no ambiguity about what this committee or this board feels about any one particular standard. I personally don't think, and people can have a different opinion, and I know it's very complex, I don't think a diversion program is a condition precedent to adopting some of those standards. I don't. Reasonable minds might differ. I don't think it's a condition precedent. I think the legislature's and the governor's intent is pretty clear in my mind that we adopt the standards. So that's where I'm at right now.
Thank you. Are there other comments, Dr. Levine?
Yeah, as I've spent time thinking about this over the last few weeks, it's occurred to me that one of the potential disconnects is that standards are different than guidelines. Standards don't leave you, guidelines leave you the ability, give you the ability to adjust based on the facts and circumstances of a given situation. And I think to some extent what we have done is said, well, we address this in the disciplinary guidelines, so you know, de facto we have adopted the standard. And we can't do that and at the same time say, yeah, but when we deviate from the disciplinary guidelines, it's based on judgment that in the facts and circumstances of the case, the guideline is only a guideline, and so we have the flexibility to adjust it. And I think to some extent we're caught in that. One is a standard doesn't give you the option of deviating, whereas a guideline says this is to provide guidance. We rely on you as professionals, as members, public and professional members of the board, to use your best judgment given facts and circumstances. So I think that's sort of where we've gotten hung up to some extent, is we've looked at it and said the words are there, but they're in different different frameworks and they're not identical.
Okay, thank you. Are there other comments? Dr. Guanadou?
Thank you. I have the same problem as Dr. Levine, is that medicine is science. It's not just a standard you apply. It's a guideline is a lot easier way of dealing with a unique circumstance. And one other issue I have is that we deal with drug testing quite often, and a lot of urine tests are screening tests. So they're not the confirmatory test. Then there is a confirmation you have to do, because you do get false positives. So that's why we want to make sure that we do it right scientifically, at the same time follow the law. I mean, that is, we understand that in the end we are employed by the government here. We do need to follow the law. So I think we need to come up with how do we marry those issues. Maybe like Mr. Serrano so well mentioned, that maybe adopt the standards and then start the rulemaking process and take care of those concerns I have in the rulemaking process. So that way, then you still dealt with the scientific part. We are scientists in the end. I mean, that's what I went to medical school for. So to really put the science back in and really do appropriately.
Ms. Shipsky?
I have to agree with David. I think we need to move forward, get these adopted, and then we can work out as the rulemaking process goes forward. It's very clear in the materials that we've been given that the intent of this bill is not to dictate specifics, but to set parameters. And I think that we need those parameters. It's been many years since this diversion program was taken out of the medical board. It's an ongoing problem, and I think the sooner we can start on that rulemaking process, the more clarification we can get. One of the things I need to ask staff that I didn't see in here, is there any standard regarding probation? Because we're often faced with someone who has been a substance abuser who then is on probation, and there is really no set guideline that I have found that they often will come to us as a board and request that their probation be removed and that they can go back into practice. So is that something that any contemplation on a standard for probation?
The standard did not address specific required time frame to be monitored, if that's the question, if I'm understanding your question correctly.
Okay. I would hope that I would hope that we somehow grapple with that.
We can if we're going to open up the disciplinary guidelines again. There's a recommended penalty, so that might be the place to deal with that framework.
But I would agree with my colleague. I think we need to move forward and get going on the rulemaking process. And in that process, I think we'll be able to fine-tune specifics relevant to this board, which I think is the intent, again, of the law, is to set parameters, but certainly then to allow the different boards, if they need to fine-tune something within those parameters. But we need to move on this.
Okay, appreciate your comments. We have 2 slips for public comment. I'd like to call on Alicia Cole, 3 minutes once again. We have a very long agenda today, so we need to be efficient.
Okay. All right, ready to go. Hi, again, I'm Alicia Cole, and I'm with the Consumers Union Safe Patient Project regarding the uniform standards. And I just want to thank you for supporting the adoption of the uniform standards and encouraging those of you who are may still be unsure. As you know, substance abusing physicians pose a significant risk to patients who typically are unaware of the problem. And when these issues come before the medical board, they should be addressed through a comprehensive and predictive process that the public has full confidence in, that is transparent and has integrity. And we've testified before to the medical board, various advocates, that, excuse me, we really see the urgency of this, and we want the full adoption of these standards. We urge you to adopt them completely and immediately. And as you know, the Legislative Counsel Bureau, the Office of the Attorney General, and the Department of Consumers Affairs has issued opinions unequivocally stating that these standards are mandatory and that they are to be used by the healing arts boards. And as you know, most recently, the chairs of the legislature's Business and Professional Committee, Senator Price and Assemblyman Gordon, in a letter threatening the very existence of the medical board, said that the medical board needs to adopt the uniform standards as required by SB 1441 in order to protect patients in California. Now, Section 1315C of the Business and Professional Code says that these uniform standards, and I quote, that each healing arts board shall use in dealing with substance abusing doctors whether or not a board chooses to have a formal diversion program. This is California state law now, and it is not within the discretion of the medical board to fail to implement these uniform standards. As you know, the medical board staff prepared a document for today's meeting relating to the board's implementation of these standards, and it is not within the medical board's discretion to pick and choose any of these possible standards. And as we stated in our testimony at the last board meeting, one of the other advocates, Tina Manassian, which was also distributed to you, and I have a copy of it here today if you would like. There are several important requirements in the uniform standard that are missing, as you know, and we want full adoption. So we ask you to come into complete compliance with the requirements of SB 1441 and that you implement them immediately. Thank you.
Thank you for your comments. An initial public speaker is Julia D'Angelo Felmuth. So just to take the heat off of me, we have a timer here. So when the timer is 3 minutes, just turn off the mics, and I think they'll get it. That's what they do at major programs, so I think we should implement that here.
Music.
Okay, just turn off the mic at 3 minutes.
You're starting with me?
Yes, absolutely.
Not
Okay.
being pejorative, Ms. Felmuth.
Okay, your time is starting.
Thank you, Dr. Lowe. Julie D'Angelo Felmuth from the Center for Public Interest Law. Dr. Levine has identified the problem. There is a huge difference between your disciplinary guidelines, which are discretionary, and the uniform standards concerning substance abusing licensees, which are not. They are mandatory, we know that. What you did was to incorporate some, but not all, of the uniform standards into your document that is called disciplinary guidelines. Then you amended your disciplinary guidelines regulation. That is the source of the problem here. That regulation is not quoted for you in these materials. I don't have it in front of me, but it says something to the following effect. In reaching a disciplinary decision, the board shall consider the guidelines and standards in the January 2012 version of its disciplinary guidelines, which is hereby incorporated by reference. Deviation from these guidelines and standards is permitted if the board, in its sole discretion, decides that deviation is appropriate. You can't use that regulatory language with the uniform standards. You have to separate the uniform standards out because they're not discretionary, as your disciplinary guidelines are. What you need to do is adopt a reg that says the following. In reaching a disciplinary decision involving a substance abusing licensee, the board shall comply with the uniform standards adopted by the Substance Abuse Coordination Committee in April of 2011, which are hereby incorporated by reference. That's what the other healing arts boards are finally doing. That is what you must do in order to fully implement and legally implement the uniform standards as required by law. Thank you.
Appreciate your
124.
comments and holding to the time. So if there are no additional public comments, I think that perhaps we should entertain a motion from this committee that we have the larger board adopt the uniform standards of SB 1441.
Yeah.
Okay, do I have a motion?
So I knew this meeting could not continue with me having to say something. So I want to be candid. Not on the merits of 1441 and its standards. I think that issue's been well discussed, well documented. I think the issue is from the legal perspective, Ms. Dobbs and myself, Ms. Webb, how do we get there? It would be my legal opinion that the board cannot just simply adopt the regulation, adopt the standards, and then move on with regulation. I believe the way you get to 1441's implementation is you adopt regulations that address the issue that incorporate the standards. The reason I say that there's a portion of the government code in the Administrative Procedure Act way back about 11.340.5 or something that says no statute, no guideline, no manual, no bulletin, no anything, no policy, no good idea, if you will, can be enforced unless it's gone through the full rulemaking process. So there's some tension there. So what I would suggest is the board may want to, this committee may want to consider recommending to the full board that it commence immediately the rulemaking process to essentially establish for the medical board the 1441 regulations, 1441 standards in regulation. And by in regulation, as Ms. Felmuth pointed out, not in the guidelines section, but a standalone section that in fact would say, if in fact there is a disciplinary decision involving a substance abusing licensee, then the following shall apply. And that takes it out of this sort of deviations are warranted, like the 13, I think it's 1361 sort of the enabling regulations for the disciplinary guidelines. This, in fact, would take it out of that discretionary rule of the board and put it more into a thou shall, the following shall apply. So I don't want to be the wet blanket. I don't want to be the most disrespected, disliked guy in the room. But I would respectfully suggest that the way you get to implementing 1441 standards would be to immediately recommend that it immediately commence to the board that it commence the 1440 rulemaking procedures, regular rulemaking procedures, and for the time so that the board may hear it at the next available opportunity.
And I'll briefly just add to that. The reason you can't get to there from here and simply just adopt the uniform standards is because we believe, and the legal opinions that we have suggest that they are not self-implementing. So if you simply adopt them and start using them, you're essentially doing an underground reg.
So what you're indicating then, that what we have to do is very similar to what was just suggested, that we indicate that they be incorporated by reference, correct? If we're dealing with this.
No, what we need to do is we need to commence the rulemaking process.
No, I understand that, but in those rules, at that point, language needs to be crafted that indicates that these, when dealing with a substance abuse physician, that these standards shall apply.
Yes.
Okay.
Yes.
I think that's where we were trying to head.
So really, it's just, we really support this 100%, but it's just the process by which we get there. And I don't think any of us are opposed to that, and I would entertain a motion that we do whatever Mr. Hepler suggested, so that we can get to that end.
Kurt said.
No, I want, as do I, and I'll make an attempt to summarize it or to restate it just for the record. But this is the benefit of having our in-house counsel, understanding our special restrictions, limitations of our authority, and giving us excellent legal advice so we can implement our policy objective within the confines of the law. So thank you. All right. So, and I think our intent's pretty clear, however we say it. So commence immediately the rulemaking process to implement SB 1441 standards in regulation. And there's a reporting aspect to it. Report back immediately to this board at its next available meeting, at its next meeting.
No, second that. Can I clarify?
Sure.
Do we have to in fact instruct that as part of this motion is that with the intent that these standards would be incorporated by reference? Or do we wait till the rulemaking? I just want to be real clear that we may go through the rulemaking process, but the intent obviously of the motion is to make certain that we do incorporate them.
Right. So let me just back up. Let me hit the brakes. I'll say two things. Number one, I think this committee's action would be a recommendation to the full board.
Yes.
Okay. Because I have people gesturing excessively. The second issue is, Ms. Shipsky, whenever we have a large document like this, we point to that in incorporations by reference, so we don't have 45 pages of regulation. But I think it would be clear is that we would say, if in fact we have a substance abusing licensee, the following standards would apply as incorporated by reference.
And that would be, I think, where we were trying to go. So I would like that certainly very clear in our recommendation to the full board.
And the motion is for the recommendation to the full board. Thank you.
Dr. Levine, do you have a comment? Okay, I just love how these attorneys can talk to other attorneys.
Yeah, I know.
Okay, so we have a motion, and do we have a second? We have a second? Okay, any other public comment, discussion? Okay, so we'll call for a vote. All those in favor?
Aye.
Aye. Opposed? Abstain? Motion carries. We'll make that recommendation to the full board. I appreciate your input, Mr. Epler. Okay, so now we can get back on track, and we will now deal with agenda item number 4. We have Ms. Laura Sweet here to give us a presentation on the update on the expert reviewer training.
Good afternoon. I'm pleased to report we had another successful expert reviewer training in February 9th of this year at UC Irvine. It was attended by over 100 physicians, and the feedback we received was quite positive. I think the training went extremely well. We did implement the new process where we're having the physicians submit an actual sample opinion, which has actually proven to be quite interesting. It's been arduous because we've been giving them individualized feedback on the sample opinions that have been provided. And I do believe this is going to be a great opportunity for us to make some amendments in our next training, because there are a couple little areas that I still think we need to see further improvement. And we are hoping to have the next training sometime in the fall, probably late October, November time period, so we can get our next 100 or so experts trained.
Where?
San Diego is where we're trying to get location with UC San Diego.
So I've attended both of these, and it's really one of the most impressive things that I've seen through the medical board. And the whole reason for these programs is that we want to raise the bar for our experts so that they understand their purpose as a consultant to the medical board. And I think you've done a phenomenal job, and I want to thank not only yourself, but your team and all the people that you recruited to speak. I mean, it truly is an impressive program. Thank you very much.
Thank you very much. It was your idea. It was a great idea.
That's why he's coming.
That's why he's saying it's.
But I had nothing to do with the actual training program itself, which you've done a phenomenal job with. So thank you very much. Is there any public comment on that issue?
Dr. Loeb,
Yes.
one of the things, though, and I think this board has said this repeatedly, and we do thank you for recommending to do this training, because the frustration that the public doesn't see is that if, in fact, the quality of our experts is not outstanding, we're often faced with having to agree to a stipulated settlement, because we find that if we were to adjudicate it even further, that our own experts wouldn't be able to support the position of the board. So I think that anything we can do to improve the quality of the experts will help with enforcement. And, again, I thank you for coming up with that idea.
I agree, and it's in evaluating the efficacy of the training is what I'm really interested in right now too, and seeing these actual sample opinions has been really eye-opening. And we haven't had an opportunity to see how the training is being reflected in the actual testimony yet, because not very many cases go to actual hearing, but we'll be assessing that as well.
Good.
Yes, Dr. Levine.
One other comment, one other additional benefit of the training, I think, is it will potentially enable us to recruit more interested physicians to provide expert review if they know they're actually going to get prepared for and this is actually a developmental opportunity for them, rather than being kind of thrown into review the case and we're going to put you on the witness stand and you better do the right thing. I mean, I think it may be a wonderful marketing tool for us in terms of encouraging greater participation in the expert reviewer program.
Okay, with no additional comments, we'll move on to the next agenda item, which is a discussion and consideration of proposal to increase expert reviewer hourly rates upon completion of the expert reviewer training program. Ms. Sweet.
Okay. Segueing into this next subject, which I do believe will also help with our recruitment efforts and marketing efforts. And after the last expert training, discussion ensued regarding the pay our experts currently receive. Right now, we pay all of our experts $150 for record review and report writing, and $200 an hour for testimony. And as we've stated many times, we believe the expert reviewer program is among the most critical aspects of the enforcement program, and the impact of a poorly considered and articulated opinion can result in decreased public protection. Such an opinion can result in charges not being filed against a physician who has violated the Medical Practice Act. It can result in charges being filed that Ms. Shipsky mentioned that can't be supported once the charges are filed, or it can result in an accusation actually being dismissed because the expert cannot adequately testify to support his or her opinion. And you've likely seen some of these situations when reviewing proposed decisions that call for dismissal of an accusation. So to ameliorate these problems, at Dr. Lowe's suggestion, we did institute the interactive training that began in May of 2012. And we have been compensating the experts who attend this training with continuing medical education credits and training that that the experts hopefully find informative and reasonably entertaining. Ideally, as Ms. Yaroslavsky suggested at the previous committee meeting, we could require experts to attend the training and submit a sample opinion that's acceptable prior to engaging them in a real case. And this vetting process to date has not been possible because of a variety of reasons, one of which is our lack of experts, particularly in certain specialties. And part of this problem, we believe, is our notoriously below market rate of compensation to our experts. During calendar year 2011, we sent out questionnaires to our experts asking them for feedback about their experiences as an expert. I'll just read you a couple of these to save time of some of the comments that were received. One expert wrote, "Rate increase for time, as this time is spent away from family or other cases. My usual minimum rate is $350 to $500 an hour. Understanding the importance of medical board case reviews, a rate of $250 per hour would be much more reasonable and allow for faster reviews." Another expert wrote, "The reimbursement rate is quite low in comparison to the private market. Since it is a service, the value should likely come closer to the difference of these two extremes, for example, $350 per hour." And regarding the neurosurgery expert shortage we have, one neurosurgeon wrote that the median rate for medical legal evaluations for neurosurgeons is $500 to $800 per hour. And that while I understand medical board can't pay this rate, there would be more willingness to participate if the rates were a little higher. The board has had significant difficulty procuring neurosurgery experts, as evidenced by the few experts available in the specialty to review cases. And currently, even though we have advertised in our newsletter, now we've advertised in the American Board of Neurosurgeons newsletter, our analyst has corresponded with academic institutions throughout the state begging for neurosurgery experts, we still only have 9 at this time. So it makes it almost impossible to get an expert review turnaround in our 30-day goal when we can't find an expert, and then once the person is kind enough to take the case, we feel kind of like ingrates asking for a very quick turnaround. So we're generally looking at more like 60 to 90 days to get those cases resolved. And then we have additional problems when it comes to the point where that expert might have to testify because their time is so valuable. We don't believe we can amass a pool of qualified vetted experts unless we're willing to pay more for our high expectations. A physician's time is a precious resource, and our rate of compensation, I believe, must reflect this reality. That said, I would like to ask the committee to entertain a motion to allow staff to seek a budget augmentation to increase expert reviewer pay according to the schedule in your packet on Section 5, page 3, which in a nutshell says that after an expert successfully completes our training and provides a satisfactory sample opinion, that their pay be raised from $150 to $200 an hour for record review and report writing, and to $250 an hour for testifying, and then for neurosurgery experts only to increase their rate to $300 an hour for record review and report writing, and to $400 an hour for testifying. That concludes my presentation.
Well, thank you very much. So at this time, I'd like to entertain a motion as she proposed, to augment these rates.
Can I ask a question? Have we had any correspondence with SFMB just to find out what other jurisdictions pay their experts?
We have not.
That might be helpful for us so that we can get some kind of sense of, and because this may be what you're proposing kind of low, and maybe as a follow-up, we could find out what other states do too as well.
Yes, Dr. Levine?
I'll make the motion.
Okay, so we have a motion. Do we have a second? Second from Dr. Levine?
And a question?
Yes.
So my back-of-the-envelope estimate is it's about $500,000 impact on the budget. Is that?
Look at my trustee. Yeah. Maybe a little bit higher, but not too much.
Okay.
Yeah. And again, it depends. If we get an influx of neurosurgery cases, we're just basing this on our previous experience, right?
Just taking it further, we do have that money available, right, in the budget without trying to get more revenues?
I believe that is correct. No? It's not correct? Yes. Yes. Yes.
Executive Director says yes.
Okay, is there any public comment?
There's a legal comment, and I just want to make sure that the motion is, of course, in the form of a recommendation to the full board.
The full board, yes.
Always
We
at the
would, we
full
wouldn't
board.
dare take it upon ourselves to move it fully.
That's right.
Yes, we have Ms. Whitney.
To answer that
We know our
specific
plan.
question, the money is not in our current budget, but we have it in our fund. So we would need an augmentation. That's why your request is to go to the full board to ask them to direct staff to prepare a budget augmentation request or budget change proposal. So we have the money in the fund. We don't have the appropriation or authorization to spend it right now.
Public comment? No public comment? Call for vote. All those in favor?
Aye.
Opposed? Abstain? Motion carries. Thank you very much. Okay, moving on to agenda item number 6. This is a discussion on history and efforts to improve retention by enhancing the investigator classification. Our Chief of Enforcement, Ms. Renee Threadgill, will give us a presentation.
Okay, thank you. Good afternoon. The chair of the Enforcement Committee asked for a report detailing efforts the board has taken to address the recruitment and retention of medical board investigative staff. The turnover of investigative personnel is by no means a new issue. This has been a chronic problem that has spanned almost a quarter of a century. Turning to agenda item 6 on page ENF 6-2 in your agenda package, I would like to highlight a few of the copious efforts of the board to improve our ability to retain investigative staff. The board has tried without much success to improve retention of investigators by seeking monetary differentials commensurate with other state agencies. A few interesting actions that we've taken include the legislature enacted SB 2375 during 89 and 90 legislative session. This legislation included intent language regarding investigator pay. The intent of the legislature that the pay scales for investigators of the medical board be equivalent to the pay scales for special investigative agents of the Department of Justice in order to attract and retain experienced investigators. Nothing ever came of that intent language. In November of 2002, Board President Gary Gitnick sent a letter to Governor Gray Davis seeking his support to overcome salary and differential inequities. The correspondence noted that it is troublesome and contrary to good management practices when a single employer, the state of California, allows some of its agencies to offer benefits in the same geographic area in which it is denied to other agencies. In January 2006, under SB 231 Figueroa, when SB 231 was enacted, requiring Medical Board and Department of Justice Health Quality Enforcement Section to implement vertical prosecution model to conduct its investigation and prosecutions. Throughout much of the legislative process, SB 231 contained a provision which specified that medical board investigators would be transferred to the Department of Justice to create a more streamlined and centralized enforcement system to achieve the public protection goal. However, shortly before it was enacted, SB 231 was amended and the proposed transfer was deleted. This transfer would have given investigators a pay increase commensurate to the agents in the Department of Justice. During 2009, the enforcement program contracted with CPS, Cooperative Personnel Human Services, Resource Services, to explore the possibility of reclassing medical board investigators. CPS recommended formalizing the investigator training program, which we were already in the process of doing. We had done it. And then crafting an official request for a two-stage pay differential suggested at 5% and 10% that focused on additional training. MPC investigators received so much specialized training that it seemed that they could receive additional compensation for completing training milestones. This recommendation was abandoned due to the state budget crisis and also because it did not address the complexity of jobs at MPC. Most recently, I requested that DCA submit a request to the Department of Personnel Administration to pursue pay differentials for training officers, range masters, defensive tactic instructors, and other formal training assignments. To date, this request remains outstanding. Being mindful of the economic reality, staff is making a modest recommendation to level the playing field with other state agencies by requesting establishment of differentials for training officers, range masters, defensive tactic instructors, and other formal training assignments, and that investigators receive pay differentials for living in Los Angeles or other high-cost areas where investigators in other agencies receive the same differentials. Additionally, it is recommended that staff work with the Department of Consumer Affairs to amend specifications for the investigator classification series to expand the subject areas of the degrees accepted for admission to the examination. And that concludes my report.
Okay, thank you, Ms. Threadgill. I think that it's well accepted that our investigators and the medical board do comparable work to the investigators in the Department of Justice, and there is this big differential. So it seems to me that it's very reasonable for us to consider a motion making the recommendation to the full board that we make these interim adjustments that are recommended by Ms. Threadgill. Do we have any comments from the board members? Yes, Dr. Guanadev.
Ms. Threadgill, I got two questions. One is that what's the process? If we make a recommendation to the full board and it adopts, then what happens? So how does this come true? And the second one is, again, with the same my MBA hat rather than MD hat, what's the cost?
I don't have the cost, but my recommendation essentially is that we work with the department to pursue those differentials for all investigators within the Department of Consumer Affairs, not just the medical board. So I guess it would impact every investigator that's in a current DCA investigator job class, because we use the same job classification throughout the department.
Yes.
I'm fine with making the recommendation, but I would like also to know the cost at the medical board. I'm not interested in any other department, so just to be.
Yes, Ms. Shipsky.
Was the problem resolved? I know that we talked about some time ago where, in terms of trying to recruit, you were limited to taking investigators that were only within the Consumer Affairs Agency, and that there was some, obviously, concern.
No, that was during the freeze.
Are you still limited just to
No, there's no freeze. Now we have to be concerned with the restrictions on hiring the SROA because of the other individuals that are being laid off in other departments.
You want to explain that a little bit?
Well, there are, in the past, there were individuals that were laid off at Department of Justice, which we gladly hired, and as soon as we got them on, we learned that they were being offered their jobs back, so we lost them again after having invested a lot of work in their backgrounds. And now there's a big layoff going on with the Department of Corrections, both with parole agents. And so we're forced to hire the SROA people before we can look to anyone else on the list, which we're doing now.
Okay, well, and again, but hopefully at some point, when you do some recruitment, you'll be allowed to go outside to the bigger recruitment pool of special investigators from other agencies, federal agencies and others.
They'd have to be on the list. They have to meet and meet the minimum qualifications, but that's after you exhaust the SROA list and the reemployment, I think, list for people who've actually lost their job within state service. So,
all right, thank you.
So, do you have more comments? Yes.
No, just.
Okay, so we have a motion.
Yeah, make the motion at the same time that as it goes through, I would like to see the cost.
Right, we need to include that in the recommendation. Okay, so is there a second?
Second.
Second. Public comment? Okay, all those in favor of making this recommendation to the full board, aye?
Aye.
Any opposed? Abstain? Motion carries. Thank you.
thank you.
Okay, moving on to agenda item number 7, discussion of priorities established in the Business and Professions Code, section 2220.05. Ms. Katie.
Thank you. At the last Enforcement Committee meeting, a request was made to explain to the committee how the board interprets its priorities that were established in statute. In 2003, Section 2220.05 was added to the Business and Professions Code, and that identified that cases involving the following allegations are to be handled on a priority basis, with the highest priority being given to cases that involve gross negligence, incompetence, or repeated negligent acts that involve death or serious bodily injury to one or more patients. All complaints alleging that the quality of care provided by a physician was negligent must go through the same triage process and review process in the complaint unit before being sent to investigation. However, those that allege that the physician's care resulted in serious bodily injury or death are flagged as urgent and are given on a priority base, are given priority status during the medical review phase. The other case types that have been designated as priority are practicing while impaired, either by drugs or alcohol, sexual misconduct, or excessive prescribing. In the complaint unit, these cases are assigned to an urgent analyst who immediately refers the case to the field for investigation without any workup in the complaint unit. The board also considers complaints that allege physician impairment either by substance abuse, mental, or physical illness to be the next highest priority, along with cases alleging unlicensed practice or aiding and abetting the unlicensed practice of medicine and criminal conviction cases. The majority of these case types are referred directly to the field without any kind of triage review in the complaint unit. Complaints that involve physicians that are currently on probation are also given a priority, but they undergo a triage review in the complaint unit prior to being referred to the field, depending, of course, on the nature of the allegations. When complaints are referred to investigation, they are reviewed by a district supervisor and by the Deputy Attorney General on intake to identify those that represent the potential for patient harm or may be considered possible ISO material or considered for a possible ISO. Finally, I wanted to give you a list of some of the other kinds of complaint issues that are received in the complaint unit. Most of these are designated as routine matters. They undergo a triage review in the complaint unit, and very few of them would result in the referral for a formal investigation. Any questions about handling priorities?
Any discussion amongst the board members? We have a public comment from Genevieve Claverol.
Good afternoon, Geneviève Clavrolle. I was wondering if the item you have are posted in priority. And personally, I think that one of the things you did not mention at all was disruptive behavior from physicians, and apparently that's becoming quite a big issue at times. And also that I felt the unlicensed to practice medicine should be at the beginning, because if you don't have that, then you shouldn't be have the all other one under it. So I don't think that's, in order of what, importance. And I wanted to know if it was any order of severity.
On the second slide that talks about the urgent cases, that's just a list. It's not given a priority order.
That's what I wanted.
Yeah.
Thank you.
Okay. No other comment? I guess we can move on to agenda item number 8. This is a discussion of the Workmen's Compensation Utilization Review Process, investigation of complaints, and we're going to hear from Ms. Katie and Mr. Hepler.
The committee has asked for a briefing on the topic of utilization review in response to public comment during the last meeting. Concerns were raised regarding several issues. First, does the board consider utilization review to be the practice of medicine? The board has addressed this issue by stating that utilization review decisions constitute the practice of medicine, and that a physician who reviews and makes medical necessity determinations is considered to be practicing medicine. The second issue is, does the board have jurisdiction to investigate complaints involving decisions made by physicians performing utilization review? The board receives a very small percentage of complaints regarding physicians who perform utilization review. This function this function is used in a variety of settings. Generally, complaints received by the board tend to fall into two general categories. The first is the denial of coverage for service or procedure by an insurance company. Complaints are received from either the patient or the physician providing care to the patient whose request for authorization for treatment has been denied as either being experimental or deemed not medically necessary. The legislature addressed this issue and declared that decisions about medical care should be made by physicians and other healthcare providers. The criteria or guideline used by health plans, insurers, and IPAs to determine whether to authorize or deny services must be developed with involvement from actively practicing physicians and must be consistent with sound clinical principles. The guidelines must be evaluated and updated annually and must be filed with the Department of Managed Care for HMOs or the Insurance Commissioner. By law, only a licensed healthcare professional who is competent to evaluate the specific clinical issue involved may deny or modify requests for authorization based on medical necessity. The decision of the reviewer must be communicated to the treating physician and the patient and must contain a concise explanation of the reasons for the decision, a description of the criteria or guideline used, the clinical reasons for the decision. The name and phone number of the reviewer responsible for the denial or modification is provided to the treating physician. Information about how to file an appeal or a grievance must also be provided to the patient and to the treating physician. Patients have the ability to appeal the decision, to appeal the denial of services to the Department of Managed Care or to the Insurance Commissioner after they've exhausted their appeal options through the carrier. The second type of complaint or utilization review function is the denial of coverage for services related to a workers' compensation injury, and Kurt's going to address that.
Thank you, Ms. Katie. Mr. Chairman and members, first let me throw a few disclaimers out at everybody. I'm not a workers' comp attorney, nor did I stay at Holiday Inn Express, nor did I play one on TV. And the issue that I have was asked to talk about sort of not on the validity of the claim, not how the UWC process, workers' compensation process works. But I considered it from the perspective of inputs into the board. And by that I mean we have a series of inputs into the board for our disciplinary process. We have complaints, we have 805s, we have 801s, we have self-reporting inputs as well. We have there's some legislative consideration of modifying coroner's reports and also to provide additional inputs into the board. The issue is kind of complex because the board has essentially, as Ms. Katie said, number one said that the practice of utilization review is in fact the practice of medicine. We say that on our website because we say you can't do it with a retired license. You have to have license. We also in the past have supported legislation that would establish a requirement that a UR physician, a utilization review physician, be a duly licensed California licensee. That is, they would hold a physician and surgeon certificate issued to the board by the board. That's not currently the case. And so we sort of find ourselves in a paradox because we have this thing that we'd like to see everybody California licensee, but in fact, we would sometimes decline to have jurisdiction over a complaint filed against a UR physician. So I looked at it from the perspective of essentially there's three parties in a UR dispute, and that would be the injured worker, sometimes called the claimant, the treating physician, and the UR physician, who again need not be a California licensee. And so we have this issue of, as I understand it, that somebody would, either the physician could, the treating physician, or the patient, the claimant, the injured worker, could file a complaint against the UR physician, presumably for denial of treatment, reduction of treatment, modification of the treatment plan. And then the question comes up, what does, in fact, the board do with that? And the reason I say that is, the workers' comp is, in my opinion, a little bit of a closed system. When there's a UR disagreement, the statute that invokes the utilization review process talks about a process by which those are resolved. That process, in my opinion, does not include the medical board. It includes lawyering up, it includes getting maybe a competing opinion, getting a lawyer, going before the Workers' Compensation Appeals Board, having the matter heard. It does not mention going to the medical board. And not to say that, that couldn't be a reasonable interpretation, it just is not there right now. The second thing is, from a pure public policy perspective, there is a complaint process as you look to the attachment, and I apologize, I've updated my memo to the April 22nd, 2013 date because the previous memo, I think, wasn't signed, and there was a couple of typographical errors and a few words. I'm not the world's greatest typist. There are a couple of words omitted, but it stands for exactly pretty much the same proposition. That there is a complaint mechanism already, not with us, but with the Department of Industrial Relations, who can impose a monetary fine in the cases where UR goes awry. So as we look at it, clearly there may be value to an input, but the question is, in a closed system like UR, what is the medical board's jurisdiction? And as I point out in my recommendation here, that it continue to establish policy of performing a preliminary analysis of the complaint, and if the complaint involves a UR issue, not a denial of coverage issue, like I should really be covered for this and I'm not, but if something that affected the treating physician, didn't do something that's within the standard of care. Now, if we talk about the standard of care, you'll know from your work on the panels that to find out the standard of care, we solicit an input, the input of an expert who testifies to what the standard of care is. In some cases, in a lot of cases, that question over standard of care is in fact answered in a workers' compensation proceeding because they have the MTUS, the treatment guidelines, or the ACO, and the guidelines already established. So there's the standard of care. I would respectfully suggest that if in fact the board wanted to assert jurisdiction explicitly over these kind of issues, that it do so in a statutory change by saying, and the medical board shall have jurisdiction over that. I think that would clarify the issue. Clearly, the medical board has jurisdiction over, normally occurring complaints or whatever. The issue is in a system whereby there's already a mechanism established to address complaints, does the medical board have a jurisdiction there? I would respectfully suggest, out of abundance of caution, if the medical board wanted to assert jurisdiction over those complaints, it'd seek a legislative change to explicitly do that. So, again, I'll be more than happy to answer any questions that any of the members may have. Ms. Katie commented this is a relatively small number of complaints, I believe. So with that, I'll be quiet.
Okay, discussion from our board members. We'll start at the end with Dr. Levine.
Yeah, so I'm trying to follow the logic chain here. We've established that utilization review, to the extent that a licensed physician can deny or delay treatment recommended by a treating physician, is the practice of medicine.
Correct.
And leaving aside workers' comp, because I think when we heard testimony about this at the last meeting, the request to add it to the agenda was broader than the workers' comp issue. It was about utilization review in general. So to the extent that a utilization management or utilization review decision results in denial or delay of care and harm to the patient, but to me the chain of logic is that doctor who had the ability to say no engaged in some activity that caused harm to a patient. So to say that we have no jurisdiction when a patient is harmed, I mean, it may not be a huge number of cases, but once we've said it's the practice of medicine, how do we not allow a complaint to be brought forward?
Respectfully, I think that's the area of tension because, first of all, we would have to do some sort of preliminary triage to figure out if the person that the complaint is about is in fact a California licensee. But let's assume for the sake of discussion that they are. The reason I am hesitant, and I understand the logic here, it's a little bit even more complex. Here we say it's a practice of medicine. The board has previously said, and everybody doing it ought to have a California license. But then we say, well, okay, that's all well and great, but if you file a complaint, we hit the brakes and it hits a brick wall. I think the issue is that the remedy in some regards, the closed system that I talk about, the remedy for an untoward decision or something untoward decision coming out of UR is in fact using the process prescribed by law, which doesn't include the medical board. So that's the tension that I see.
Well, these are two issues. I think that we're getting things confused. One is, there's a difference between what the patient wants and what UR says, and that dispute resolution occurs within their own system.
Right.
But if the UR physician is practicing medicine in a way that we think is unsafe, then that's something that the medical board can deal with, and that's totally separate. And I don't think that that should ever go away, and that message needs to be sent to all UR physicians that they still are under the medical board for the way they practice medicine. Does anybody disagree with that?
Well, I thought that's what I was hearing, the disagreement that we legally, even though we call it practice of medicine, but the complaint can't be resolved by us. That's why it didn't make sense to me either. Take workers' comp is maybe a closed system, but like Dr. Levine, my point is utilization review, denial by a physician and another physician request is practice of medicine. If there is, if that delay in care or denial of care causes harm to the patient, that is practice of medicine. So why can't the medical board be looking into it?
Because we're not in the business of dispute resolution. All we're doing is we practice and protect people against bad doctors. And that's what we want to continue to do, and we want to include those UR doctors. I think that should be our position. Yes, Ms. Shipsky.
I think you're agreeing with me, yes. That's what, you're agreeing with me. Actually, those doctors should be included. That's what my point is, that we should, if they deny care or delay care for some self reasons, whatever it is, I think we should be looking into disciplining those doctors. That's what I'm.
Yeah, because sometimes, the UR doctors are conflicted because their goal is to their employee, their responsibility is to their employer, and for their employer, many times, the goal is not optimal patient care, it's improving shareholder value, which means making more money. So, I think that, we're not in that. I don't think the medical board wants to get into that whole business. We want to just regulate doctors. And if you practice bad medicine, whether you do surgery or whether you do UR, you're still under the medical board, and that's what we want to stay with. Okay, other comments from board members? Yes, Ms. Shipsky.
Well, actually, I have played a workers' comp attorney, not on TV.
Okay.
The difficulty about the UR system is that the majority of these UR, first of all, most UR in workers' comp is not done by doctors.
Right.
It's done by nurses, period, and sometimes even clerks.
Right.
Okay, because in California, they take the ACOM guidelines, they look at it, and they go, nope, we're not going to approve that. The difficulty is that we really, as a medical board, need to maintain, obviously, jurisdiction about the quality issues, and that's not something somebody can file with DIR on. A denial of benefits has nothing to do with any allegations that because the delay in treatment, this is what happened, that. The other issue is the fact that the majority of UR physicians are not in California. And at some time, legislatively, we need to deal with that, because we would not allow that to happen for other insurance issues. But, these physicians that are hired, and we can get into the whole corporate practice of medicine issue too as well in this, that they do take directions, that they're not even California physicians. So they're out of our jurisdiction somewhat. But I think for those physicians that are in California who really do this UR, I think it's important that we send the message. The medical board can be involved in matters of patient quality, the care that's given to that patient, if it's appropriate or not.
Yes, Mr. Sewell.
I too had the pleasure of practicing workers' comp law for 6 months and was grateful when I was reassigned to another team, because it is a difficult body of law. I mean, it's all code driven with a few key cases that guide everything. You go to the workers' comp, your local's workers' compensation board, it's like the Wild West in there. I mean, there's just so much going on. And the only thing I would say, and I think it's cautioning everyone, workers' comp law, those procedures are well established. It's a unique, discrete process with employers and corporate, asserting jurisdiction, however you want to describe it. I don't know, it seems complicated to me. And I don't know how it just seems, very challenging.
I would agree. I think that's why you see out of abundance of caution, if the board wanted to do that. And I certainly understand the public policy concerns. And again, this is a legal perspective, certainly not the policy position of the board, in that you may want to consider, like I said, an explicit statute to do that. I think that one could work hand in glove well with the California licensee requirement. I would just be concerned that if we were to take, again, there's various stages, as Ms. Keaty, I think, pointed out a couple agenda items. Again, there's the complaint process, and then that morphs into the disciplinary and the investigation process. What we're talking about is sort of the de facto, we're not going to go any further because this is a workers' comp complaint. I think that's what we're really talking about here. I think if we wanted to, because that ultimately may lead into discipline, I think the medical board, in a sense, would want clarification by statute or some other means that, in fact, yes, this would be the legislature's directing you to take jurisdiction over that kind of complaint.
We do receive a number of complaints that all focus on surround the same issue. So we need to make sure that we're going to be respectful of the other types of issues. Independent evaluations by a physician, we look at it from the same perspective. From the complaint, we try to drill down to what's the doctor's role in that patient care scenario. If the role was limited to providing just an opinion about the patient's care, an opinion about additional need for treatment, opinion about whether a benefit is needed or whether they're disabled or not, we have no authority to overturn that decision or influence that decision in any way. So in all of those types of scenarios, we sort of take the same approach. It's an objective opinion about a patient's condition, and there are remedies that are available should that decision be challengeable or appealable. We also have to look at what priorities have been established, both statutorily. We always focus on those that represent the greatest potential for patient harm. And we focus on fitness for practice. We focus on those that have a direct doctor-patient relationship that have directly affected the patient's care. So those are some things we ought to think about as we're moving down this path.
Thank you. For the people that just came in, this is the Enforcement Committee meeting. We're running over. I know you're expecting the full board meeting, and that will start as soon as we finish. We have some public comment and then another agenda item. So for public comment, we have a team that's going to address us. This is Yvonne Chong and Steve Katolika.
Yes, sir. Thank you, Dr. Lowe, committee members. I appreciate Dr. Levine's perception in the discussion. We think that the question that was answered in the memorandum was the wrong question. The question that was raised in our testimony last month, or excuse me, in January at the last meeting, had to do with what is the jurisdiction of the board with respect to a complaint, essentially of malpractice. If UR is in fact the practice of medicine, then in fact there should be a way for an aggrieved injured worker, in this particular case, or any patient, to seek some redress from the board and some discipline of the physician who's responsible for that practice. I told the committee in January about a California licensed UR physician who was working on behalf of a work comp insurance carrier that decided to cut a chronic pain patient off cold turkey from opioid therapy regimen that he had been following successfully for a number of months. And subsequently, due to the inevitable and severe physical and mental withdrawal, this individual landed in the ER. We understand that that individual actually filed a complaint with the board and was told that the board had no jurisdiction, partly because of the complaint, I think the confusion that we experienced in the conversation earlier. The board's responsibility for patient safety is even now more acute with the implementation of a completely anonymous independent medical review process within a workers' compensation system. And we urge the board to actively engage in this issue and assert its responsibility to protect the public. Mr. Hepler, the medical board senior staff counsel, provided that memo, and as I mentioned just a moment ago, we believe that it went the wrong direction and is really not addressing the question that we had asked be addressed. That said, we want to compliment him on even attempting to try to discern how UR is done in workers' compensation. It's not easy. It's very litigious. But our question had nothing to do with whether or not the board has the ability or the right to overturn a denial or a delay or a modification of care. That is not the question. The problem that faces the medical board, the problem that has to be addressed, is the board's jurisdiction over a licensee when a patient experiences any harm as a direct result of the licensee's denial of care. Harm, such as an unnecessary cold turkey withdrawals that land the person in a hospital in serious or maybe even critical condition, subjecting the patient to deterioration of their overall condition and their ability to return to work, not to mention, if you don't mind talking about money just a little bit, the insurance carrier's extra costs because of those issues that come up. Following upon the board's longstanding policy that UR is the practice of medicine, UR doctors must be held accountable for the results of their decisions just as any other practicing physician would. Essentially, the memo states that UR complaints can be boiled down to whether a standard of care was met or not. That's only partially true, and as I mentioned, that is not the main issue. The main issue is accountability for what happens to the patient after the UR physician denies care. If a patient, under the care of a licensed physician practicing medicine under the jurisdiction of the board and practicing within the standard of care, experiences an adverse outcome, is not the treating physician still accountable? Cannot a complaint be lodged with the medical board and perhaps a lawsuit filed as a result of the adverse outcome? It's no different when a licensed physician practicing medicine as a UR physician decides to deny authorization for care, and as a result, the patient experiences the same adverse outcome. We believe that the memo assumed that the UR physician in California work comp system hides behind or is covered by the employer's immunity from tort liability, and that should not be the case. If I might put it in terms of a question, does the board walk away from a complaint that is subject to a malpractice action by saying we can't rule in the civil lawsuit? That there is a remedy to obtain care for an harmed patient does not mean there isn't a board role with respect to the licensee's violation of the standard of care. The board must be equally engaged whether the care is paid for by a group health or commercial health care plan or a workers' compensation insurance carrier. There's nothing about the fact that a UR physician is employed by a work comp carrier that relieves the board of its obligation to enforce its authority over the licensee's conduct. If that were true, then every physician that's contracted with the employer's medical provider networks, which is a closed system of care, could also avoid having any malpractice insurance because they're hiding behind the employer's immunity. And of course, we know that's not the case.
So your time is up. You want to?
I'd like to make our request to the committee that they recommend to the whole board that it quickly and unequivocally reaffirm its jurisdiction over the medical decisions made by California licensed physicians and surgeons who conduct utilization reviews. And because of the apparent internal confusion over the policy and jurisdiction, we also request that the committee recommend to the board that it create a plan to direct enforcement staff to implement enforcement oversight over these decisions that have adverse effects on injured workers. And for the sake of California's injured workers, the board must communicate directly to the workers' compensation community its standing policy and enforcement procedure, together with, we believe, a simply stated set of instructions that can be provided to injured workers when they feel that they've been aggrieved by the actions of a licensee practicing medicine as a utilization physician. Thank you very much.
Okay, Mr. Hepler, do you have a comment? Okay. Okay, so Yvonne, did you want to make
My
some
comments are very brief.
Sure.
Yvonne Chung with the California Medical Association. Thank you to everybody who made my points so much better than I would have made them. My comments will be very brief. We would support Mr. Katalaga's request as well in terms of the specific recommendation that we'd like the enforcement committee to pass on to the medical board. Full board tomorrow. Just addressing a couple other issues. On the issue of the fact that the medical board does have a lot of priorities, we understand that, but I think that I want to clarify that we're not asking that this be moved to the top of the list. All we're asking is that it be clear that the medical board does have full jurisdiction, and the extent to which that falls in the line of priorities is another issue, but that is not a reason to exclude it from the medical board's jurisdiction. And finally, I would like to remind the board that this issue was raised as part of the medical board sunset review as well, and the recommendation from through the Sunset Review Committee was that the medical board take action on this issue and clearly specify that the utilization review is the practice of medicine and should be enforced as such. And we look forward to your response. Thank you.
Appreciate your comments. Next public speaker is Genevieve Claverol.
Good afternoon, Geneviève Claverol. I am very pleased to hear that you feel that utilization review is a practice of medicine, because I will not be the cripple I am today if indeed the utilization review could have been a challenge on a lot of my treatment. And you said you have not heard a lot of complaints from patients not receiving treatment. I think the amount is very enormous, but most individuals who are injured on a workforce know that they have some avenue to complain and do something. For myself, who have not received the appropriate treatment, I am an RN. I've been director of nurses many times in my life. I am a PhD in hospital management, and I could never receive the care because utilization review was accepted as fait accompli. And I think it's criminal what's going on right now. And the reason myself I am fighting is because I can do it, but it's a lot of individuals who do not have the background that I have, who absolutely are, their life has been totally ruined and can no longer work. Myself, I feel that even now, actually, yesterday I got an email for utilization review. I'm not entitled any physical therapy because I have already used my 24, I have had multiple surgery since my initial, therapy. I have had a bone transplant. I have had, fusion in my leg and so on, and I have refused all therapy, and that's happened all the time. I will love that you take as a project to really make utilization review a medical practice issue for the people who really are in pain all their life. And thank you so much for listening to me.
Thank you. And our final public comment will come from Julia D'Angelo Felmuth.
Good afternoon, Dr. Lowe and members. Julie D'Angelo Felmuth from the Center for Public Interest Law. I fully understand and appreciate that workers' comp is a separate animal from this board and that it is administered by multiple other agencies. However, UR is the practice of medicine. And if a UR physician continuously refuses to allow medically necessary treatment to injured workers, what can or will the Department of Industrial Relations do to that doctor? The memo says that DIR might fine the doctor. Do you ever find out about those fines? Can it disbar him from being a UR doctor? And if so, do you ever find out about those actions? The bottom line is that you are the only body in California that can impair a physician's license. And if some other agency is administering a process that identifies potentially dangerous physicians, you should figure out how to get that information. It's like the 805 process, where hospitals are supposed to be reporting to you adverse peer review actions that they have taken against physicians. UR is a medical decision with medical consequences. At your sunset hearing last month, this board was criticized for not being proactive, and I think the legislature might like a more proactive approach as opposed to a we have no jurisdiction approach. If that UR doc is licensed in California, you do have jurisdiction over him, and you ought to figure out a way to get information from the Department of Industrial Relations about those physicians who have been fined or disbarred for UR work, and you should assert your disciplinary jurisdiction over those doctors. Thank you.
Appreciate your comments. So I think it's proper at this time that we enter, yes?
Just want to make a motion.
Okay, so I think it is appropriate at this time that this committee make a motion to the full board to reaffirm that, in fact, utilization review is the practice of medicine, and we maintain jurisdiction over their medical license just as they would be for any other specialty. But again, just to clarify, we're not in the business of dispute resolution. In other words, we can't solve those problems. That's not our job. They have their own channels to settle those things, but if the UR doctor was practicing medicine in a way that is truly malpractice, you file a complaint or we get notification through something like an 805, and then we will investigate and we'll have our consultants and experts look at it just like we would any other case. I don't think the medical board feels differently about that issue, so I'll entertain that motion.
Thank you, Mr. Chair. As I mentioned, delay and declining care is practice of medicine, so let the medical board recommend to the full board, let the committee recommend to the full board that utilization review is practice of medicine, and direct the staff to come up with the appropriate guidelines in disciplinary actions, just like any other physician practice, for the next board meeting.
Yes, Dr. Levine.
And a friendly amendment, and to clarify any necessary legislative or regulatory changes that we might need to actually make that happen.
Yes, with that amendment. Is there a second?
Second. I have a question.
Yes.
On the enforcement side, in terms, we require that where physicians practice, that there must be a posted, information that they are regulated by the medical board. So I would hope that that's being posted in worker comp clinics, and/or that the physicians are disclosing that on their sign-in sheets. That's what some physicians are doing now. Instead of posting it, they're actually, when you sign up, they let you know that they're regulated. So I'm hoping that we're enforcing that provision.
Any of the treating physician relationships, which would be the clinics you're talking about, they do post that.
No, I think Ms. Shipsky's, you're talking about the decision to modify or deny treatment. That's when the medicine happens, correct?
Right, but that often, these are often directed, these are physicians that are directed as a consequence of the UR, but I just want to make certain that workers' comp clinics and those worker comp physicians who do nothing but workers' comp, that they still, if we're indicating that for the purposes of UR, we are asserting that we have jurisdiction under that practice of medicine, that in fact that they are following the same as other doctors have been required to do in the posting, that they're regulated by the medical board.
Okay, thank you. Public comments regarding these motions? No public comment. We'll take a vote. All those in favor, aye.
Aye.
Any opposed? Any abstain? Motion carries. We'll make that recommendation to the full board tomorrow. So finishing up, we have one additional agenda item, and this has to do with the establishment of a task force to develop and address the best practices related to prescribing controlled substances to relieve pain and examine the Medical Board of California guidelines. And so I guess they've asked me to talk about that. So this agenda item, the establishment of a task force to examine the pain management guidelines relating to prescribing controlled substances, arose from concern regarding the prescription drug overdose, quote, epidemic, end quote. Last month, the board co-sponsored the Pain Summit in San Francisco, and it was a huge success, as evidenced by the number of people who attended. More than 400 people registered, and there was no additional room. So various presentations were given from a variety of experts relating to prescription drugs, law enforcement entities, pharmaceutical representatives, and regulatory agencies. Many of the statistics given at the summit were quite alarming. Prescription drug overdoses have now overtaken motor vehicle accidents as the leading cause of injury-related death in the United States. This is an issue with a variety of contributing factors, and one thing is for certain. It is an issue that has been at opposite sides of the prescribing spectrum for over the years. To give you some background, prescription drug regulation came to the forefront in the 1970s with the Federal Comprehensive Drug Abuse Prevention and Control Act, which spawned the Uniform Controlled Substance Schedule. Drugs were scheduled based upon their potency, addiction, and abuse potential. So in California, Schedule II drugs had to be written on a special, quote, triplicate, end quote, form, and databases were maintained to track these drugs. So that was in the 70s. In the 1980s and early 90s, much attention was given to the concern that too many patients suffering from intractable pain conditions were being under-medicated. There were successful lawsuits alleging patients who were dying of cancer who were left to suffer because of physicians' fear of the law enforcement scrutiny for prescribing scheduled drugs. So in 1985, the medical board created guidelines for the treatment of chronic intractable pain, but very few practitioners implemented the guidelines. So in 1990, the Intractable Pain Treatment Act was implemented when studies confirmed that physicians were under-medicating patients, and this was largely because the physicians feared regulatory scrutiny. So Business and Professions Code Section 2241.5 was derived. This is an important section because it states that no physician and surgeon shall be subject to disciplinary action for prescribing, dispensing, or administering dangerous or prescription-controlled substances for a condition causing intractable pain when certain conditions are met. So in a nutshell, most of that criteria is set forth in the pain management guidelines the board first published in 1994. The guideline includes taking an adequate history and physical exam, having a treatment plan with objectives that is individualized to each patient, providing the patient with informed consent, periodically reviewing the course of treatment, obtaining a consultation as appropriate keeping accurate and complete records, and complying with controlled substance laws. In 2002 through 2003, a task force was convened to revisit the guidelines. The task force did not recommend changes in the guidelines, but annotations were made to each guideline and investigation standards were set forth. So several other pieces of legislation followed. One called the Pain Patients Bill of Rights, which exempted physicians treating terminally ill patients from having to use triplicate or special prescription forms. In 2001, physicians were required to complete 12 hours of CME in the subject of pain management. And I think this was tied to actually their renewal of their medical license. In 2005, triplicate prescriptions were eliminated by SB 151, and all controlled substances prescriptions versus only Schedule II drugs could be written on a tamper-resistant form. This was largely to take away the stigma of triplicate prescriptions and some physicians' reluctance to use triplicates. At one point, the board's funding was attached to investigators receiving training on conducting pain management investigations. So now we get to 2010, where there were over 38,000 unintentional drug overdose deaths in the U.S., over 22,000 of those attributed to prescription drugs. Drug-induced deaths became the leading cause of injury-related death, beating out motor vehicle accidents. Studies show that prescription drugs are the gateway drug to heroin use. The economic impact is also devastating. Obviously, it's time to closely look at how the medical board is addressing this in our investigations and in our policies. I would like to solicit volunteers to work with our staff on a task force to determine if changes in our policies relating to investigating these cases are necessary. We also need to assess whether or not changes need to be made to our pain management guidelines to make sure certain they comport with the changing times. I'd like to hear from our board members on this committee, and Ms. Yaroslavsky's in the back with her hand up. Yes. I'll volunteer. Oh, you'll volunteer. Okay, we have one volunteer. Do we have another?
I'm going to make a motion first so that we can discuss it, to make a motion to incorporate Dr. Lowe's recommendations.
Second that. Just to comment, I think it is, we went from pain management and not getting enough pain medication to really the prescription drug abuse, you can say, at all levels. Patient level, doctor level, family level, everywhere. I think it's time we seriously look at it is important. I think pain was important, but at the same time make sure that patients with pain don't suffer. I mean, this was done at Kaiser system, where they significantly cut down the number of prescriptions by educating the doctors and implementing what we are talking about here. So I'm totally there, and if I would, if Dr. Bishop doesn't mind, I would like to volunteer him for this.
So I think you mentioned many of the stakeholders. I think we shouldn't forget about the pharmaceutical companies who have been very clever and developed new forms and new delivery systems for pain medications, which were very lucrative. And so I think a lot of people have some responsibility in this area of abuse. So, so we have a motion, we have a second from Dr. Levine, and we have volunteers, Ms. Yaroslavsky, Dr. Levine, and Dr. Bishop. Do we have any other volunteers? And here's another, yes.
Could there be some sort of a registry or something where we could have people sign up?
A what?
To be on this task force?
Yes.
I'm sure we can develop, but I think we can give you a contact at the medical board to call. Okay, it'll be an open meeting. Yes, Dr. Levine.
Yeah, can I make a recommendation that we actually think about inviting interested parties to participate and then convene a meeting? Because I know that certainly the California...
Do I have a volunteer to be chair of that task force? Do we have volunteers? How about a chair?
Ms. Yaroslavsky.
Okay, so Ms. Yaroslavsky is offered to be the chair of this new task force, which I know will be extremely effective and efficient.
I would second the motion of inviting the interested parties.
Okay, good.
And would that include looking at the additional issue of, and I don't know the correct legal description of this is, but using, we've been accused of not using suspense orders as much as we should be able to do that if in fact we do come upon a physician. And that has never been, I think, really addressed. And
Well,
I don't know
hopefully
if
that can be addressed in the task force.
I'm looking to legal counsel to see if that's something in
Speaking
that.
of the utilization of the ISO process in this regard,
Absolutely.
I think the task force / committee / interested parties meetings could certainly address sort of the remedies available to that sort of thing when they found a physician or physicians or other licensed healthcare personnel prescribing inappropriately or excessively.
And I think that'd be very helpful, not only for the board, but for the public, so that we can see what those parameters are, because that has been a public issue raised, and without any kind of defensive response about, the limitations. So I think we need to get that out on the table.
Thank you very much. So no further discussion, public comment, yes, one public comment from.
Two, I think.
Oh, two public, I'm sorry. Two public comment. Yvonne Chong from the CMA.
Good afternoon, Yvonne Chung with the California Medical Association. Thank you to this committee for taking the initiative to establish this task force. I wanted to let you know that CMA has already started on this effort as well, and we would be more than happy to participate in this process. We've developed a fairly substantial database of resources and academic journal articles and other resources on this area, precisely looking at whether or not guidelines need to be developed. We're also expecting to have a white paper developed hopefully this summer. We're working on it right now. We're in the process of finalizing it. That does take a look at best practices for physicians who are engaged in pain management. The target audience is kind of the general physician, not necessarily the pain management expert. And our team of physicians that have been working on this paper include experts from nationally recognized experts in pain management, occupational medicine, addiction medicine. So hopefully we will be able to share our resources with the medical board. Thank you.
Well, thank you for your comment, but I think importantly we must include the primary physicians that take care of the patients, because many of the pain medicine physicians don't write for the chronic pain meds. They expect the primary care physicians to do it, and so that's kind of a source of, discontent.
Right, and that's one of the tensions we're trying to work out in our paper is, at what level do you write so that, for the primary care physicians, what should be the relationship? At what point do you refer to a specialist, and trying to make that a little bit more clear, particularly for physicians who may be very rarely prescribing pain medication.
Well, I've been working very hard on something to measure pain. So once I have that, then we'll solve the problem. Okay.
Thank
so
you.
Our last public comment is from Genevieve Clavel.
You're getting to pronounce my name better every time.
I did take some French, but I never did very well there.
Well, this is Geneviève Clavel again. Actually, I have been very involved in on that issue of chronic pain and opiates use and so on. I'm also a journalist, an economist, and I had written two papers actually. One is a great opiate debate of 2012, was very recently, and one on chronic pain. I have attended many of the meetings on bills having to do with opiates. I would love to participate to your task force in a measure you will allow me to. And I think it's a lot of misunderstanding. And many times there is abuse also because of physicians don't know how to prescribe and so on. Like an example in my case, I have one physician with an orthopedic physician. This is the only physician I allow to write any pain medication for. But every time I have surgery, the surgeon will say, "Oh, how much Vicodin?" They volunteer to give, and I think it's what's happened often. You have patients who have a regular, physician, they are on pain medication, they go to the hospital for another procedure, and the doctor will push the drug down, to them. So I think that's very important, and I think is why we have to have a bank of information where people know exactly what kind of drugs the patient are getting and how often. I think that will cut a lot of abuse, and also to teach a patient how to utilize the pain medication. And myself, I have a very large dose of morphine around the clock, and Percocet, and lidocaine patches. That's why I'm here standing and talking. But I think we really need to keep a look at that, because there is a lot of abuse, because people don't know of alternative also. Sure. And I think, like I said, I have done a lot of research on that subject, and I think you need to prevent it. But I think we do not need any kind of article who give thousands of people die, of overdose of opiates. Because now we have physicians who are freaking out and refusing to prescribe drugs. And actually last week, my daughter who also has fibromyalgia like I have, the doctor said, I'm going to put you on detox. If I had not been there, she will have committed suicide that day. So I think, a lot of teaching has to be done. But, in the state of California, the article showing where the 1,000-some deaths over 5 years in 4 counties, those 4 counties in the state of California represent 22 million individuals, and many of them are in pain.
Thank you. Okay, so final thing is agenda items for the meeting in July 2013.
Dr. Lowe, before I think we get to that point, Ms. Dobbs, correct me if I think we have an outstanding issue still on with item 10, the SB 41441. I believe one of the things that should have been discussed there was, I believe there's a request by the Attorney General for comments on the request for a legal opinion made by the Board of Pharmacy is regarding to SB 1441 and the applicability of the standards to the Pharmacy Board, if I'm not correct, Ms. Dobbs?
Well, to all of the boards.
To all the boards. And so the AG, the Pharmacy Board has requested a legal opinion from the Attorney General from the Pharmacy Board's perspective about the applicability of 1441 and the obligations of the Pharmacy Board. Pursuant to that request, then the AG's office then sent a letter to the Medical Board asking, hey, Medical Board, do you wish to comment on this upcoming opinion?
So where are you going with this?
So for us to comment, I would, legally or whatever, the question would be if you want legal counsel to comment upon that, we would have to have, I think, the board direct its legal counsel, all of them, to comment about this. In light of what happened and the discussion, the action taken by the board, perhaps I would respectfully submit that perhaps the Medical Board should have perhaps want to focus its efforts on immediately progressing and commencing the regulatory process, and perhaps not immediately addressing.
Mr. Chairman, to that point, our actions are speaking louder than words. Let that as our response to those questions from a unit within the Attorney General's office. I saw the same letter. We're commencing the rulemaking process. We've gone on record. We're embracing 1441. It'll be up to the Attorney General's office to give their legal advice, but we need to start the process.
Well, I agree with you, but I think that, Kurt brought up some good points, and maybe he could write a memo outlining the logistics and his thoughts, which he gave to us, which I found very beneficial and might be very helpful in guiding them.
Or make a request of legal counsel to draft.
I have to say, I have some apprehension, given how well I did on the workers' comp memo.
So, Ms. Shipsky, do you want to make that as a formal?
Yes, I will. Make that motion.
Okay, is there a second?
We request of the board's counsel to draft the appropriate response reflecting the actions taken by this committee
Okay, good.
today.
And we have a second from Mr. Sewell, and discussion amongst the board members.
And we
None?
will make that recommendation to the full board that they concur in this.
Okay, no public comment? No public comment. All those in favor, aye?
Aye.
Aye.
All those opposed? Abstain? Motion carries. Final agenda item is agenda items for the July 13th meeting of this enforcement committee. We have a number of items that we'll include, but are there any additional ones? Okay, great. The meeting is adjourned. I thank you for your very patience.
That's next, that's the full board. Okay. Great. Thank you all for your patience. This has been a long but very rich day of discussion, and I think we're ready to proceed. And I apologize to our guests from the 4 accrediting agencies for probably throwing your schedules. Hopefully, you're not going to miss flights tonight, but in the interest of doing the people's business, it sometimes is difficult for us to adhere to a time frame. I want to ask everyone, I'm Sharon Levine, President of the Medical Board of California, and we are now calling to order the session of the full board, the first session of the full board during this board meeting. I would ask everyone to turn off their cell phones and for board members to try and take them off the table because they interfere with the communications technology. Board members may be using laptops to access the information for the board meeting. We have a designated time on the agenda for public comment, both for items not on the agenda, which I will call for, and then I will ask for public comment on each agenda item. If I forget to do so, I can count on my loyal counsel to remind me, I know. And if not, anybody feel free to wave your hand and remind me that I've forgotten this. And I would ask, particularly given the time, that speakers limit their comments to 3 minutes. Our hope is to end today, I guess around 6, and reconvene tomorrow at 9 a.m. And we only have really a single agenda item, or a couple of agenda items for this afternoon. So we will, one large agenda item, and we will proceed. And we are very interested in hearing the presentations of the 4 accrediting agencies. So I will call the meeting to order now and ask Ms. Toof to please call the roll call.
Dr. Bishop?
Here.
Dr. Diego? Here. Dr. Gonadev?
Here.
Dr. Lowe?
Here.
Ms. Pines?
Here.
Dr. Solmonson?
Here.
Ms. Shipsky? Mr. Serrano Sewell?
Here.
Ms. Yaroslavsky?
Here.
Dr. Yip?
Here.
And Dr. Levine?
Here.
Thank you.
And we have a quorum. So can I ask if there are public comments on items not on the agenda? I don't have any slips at this point. Okay, then we will proceed to approval of the minutes from the January 31, February 1 meeting. We have received an email correction on the minutes from one of our members of the audience whose name was misspelled. And so we need to replace the correct spelling for Carol Gottstein. And we replaced the 2 T's in her name with a D. So we will make that correction. And any other additions, corrections of the minutes from our last board meeting?
Move to approve the minutes.
Second.
Any,
Dr. Levine, just one quick thing. On page 10, you misspelled, or somebody misspelled Assemblymember Huesol's name.
Uh-oh.
thank you.
Not a
No.
good thing to do.
Not in a public document.
Right.
Did we promote him, though?
He is now senator.
Exactly.
Oh,
What the amendment encompasses any spelling changes that need to happen, the motion and my second.
thank you. A blank check.
Yeah.
All right. All in favor?
Aye.
Opposed? Great, then we're going to move on to presentations by the accrediting agencies, and we're going to start with a background and introduction by Mr. Hepler and Mr. Warden.
Okay, so today's presentation is about Outpatient Surgery Center, and our
presentation that Mr. Hepler and I are providing is some general background information. It's in your packet under Agenda Item 4. We are going to start with the, in your packet, you have a very, well, not totally detailed, but very detailed memo from myself regarding the outpatient surgery centers, and our presentation is sort of a very condensed highlight of that. And basically, Mr. Hepler is going to get to start off first, and we have all 4 of the accreditation agencies here to do their presentation to the board, and it just gives you a background of how the accreditation agencies and outpatient surgery center accreditation sort of came about.
Thank you, Mr. Warden. It's my pleasure, Madam President and members, to discuss this issue. So when we talk about outpatient surgery centers, and there's some common understanding that this is a relatively new issue, I just wanted to point out that the legislature, in fact, in 1994, the chief policy-making organ of this state, did in fact say that the legislature finds and declares that there may be some things going on in regulated hospital, out-of-hospital settings. The legislature further finds and declares that these, paraphrasing, need some oversight. So there is some historical background for outpatient surgery settings. Next slide, Mr. Warden, if you wouldn't mind. So where the rubber meets the road as far as the physicians are concerned is basically Section 2216 of the Business Professions Code. And again, I'm not a physician, I'm an attorney. And so I'll just paraphrase this. It says no physician and surgeon shall, without getting into my definition of anesthesia, shall essentially not perform procedures requiring a level anesthesia, that of a general, unless these procedures are done at a setting that is enumerated in Section 1248.1. And so the upshot of this is the determining the threshold question is, what's the level of anesthesia, number one, and number two, what's the setting? So what's the level of anesthesia, what's the setting? So again, 1248, the common thread, if not going to read it to you because I know time is the essence, an outpatient surgery setting essentially means you're administering anesthesia at a level where the loss of life, there's a risk of the loss of the life-preserving resources. Again, from my understanding, that's not conscious sedation, that's not a local, that is into general anesthesia. And again, please feel free to correct me at any time that I fully misunderstand or misapprehend the proper level of anesthesia. So the required settings enumerated in 1248.1 essentially are 2 of them for the purposes of our discussion. Subdivision D says any primary care clinic license under Subdivision A and any surgical clinic license under Subdivision B of Section 1204. And then the import of that is when they talk to who's going to license those facilities, let me unequivocally state it's not the medical board. That's the Department of Public Health. That's, we have the us and theirs, or the Hatfields and McCoys, or who's with us and who's against, it's us and them. Those are, in fact, their facilities, okay? They license those facilities. Now, moving down to Subdivision G, an outpatient surgery setting accredited by accreditation agency approved by the division pursuant to the chapter. In order to simplify matters, let's consider those our settings. They're not our settings like we license them. They're our setting like they're approved. The accreditation agencies that we approved have essentially accredited them. Okay? So we have 2 sets, one issued a license by DGS and the other being accredited by accreditation agency that we approved. So again, 2 sets. So outpatient surgeries essentially are authorized in one of the following ways. As I just said, they're either licensed by DPH, they're accredited by an agency that we approve, or they fit another statutory classification. And I'll just mention a few. They're a tribal clinic, they're a Medi-Cal certified Medicare provider, they're an institute of the federal government, stuff that are specifically enumerated. They operate outside of DPH's licensure and outside of our accreditation. Well, things were going along swimmingly to some extent, I guess, with that 94 statute. And then there became an issue that arose, and that issue was Capon v. Shuri, a 2000 Court of Appeal case that stood for the proposition, if you will, that under the differentiation or the discrete logic of DPH's licensing and the medical board's approval of accreditation agencies, CAPEN essentially stood for the proposition that if, in fact, an outpatient surgery center had any part of physician ownership, that is, in part or in whole, DPH would not license them. And where that had the practical effect of taking a relatively small number of accredited sites and throwing a whole bunch in there, because now physician-owned OSCs were calling us saying, DPH won't license us. We need a license for reimbursement. We need a license to issue drugs, to stockpile drugs, all that sort of stuff. What can we do? And the what can we do fell into you can become accredited by one of the accreditation agencies approved by the board. So I don't have the statistics, but I'm presuming that the number of accredited outpatient surgery centers sort of spiked in 2008, 2009, late 2007 as we and Department of Health Services had to deal with the ramifications of CAPEN. And with that, I'll turn it over to Mr. Warden, who can speak to the rest.
Okay, for the medical board to do outpatient surgery accreditation for accreditation agencies, we had to develop the regulations in order to implement the laws that were created. And we did that through the regulation process, and those regulations can be found in California Code of Regulations, Title 16, Division 13, Sections 13.2 through 13.6.
Okay, so as we go through this, I just want to keep three primary concepts in mind. These are all important. An OSC at a surgery center is a place. It's a place, I talked the last time, I guess my analogy was lost, it's a bricks and mortar place, but it's a fixed location and an address. Like I said, if we had a vehicle with a GPS, we could drive there, okay? I want you to contrast that, to the next slide, Mr. Warden. I want you to contrast that to a personal license like the one that the physician and surgeons have on this board and the one that Ms. Shipsky has. And this is a personal license that follows around just like my law license follows me around. I can say brilliant things in Blythe. I can say brilliant things in Alturas, San Francisco. I can even say them here, and I can say them in my office because it follows around. Okay, that's not the case with an outpatient surgery center because, again, that's a place. We have the accreditation agencies accredit a place, not a license, okay? And recall that a license is, in fact, something that is essentially a provisional grant of authority. It allows you to do something that if you didn't have the license, you can't do. So we have the difference, accreditation or license of a site versus the personal license that a physician and surgeon has. So, Mr. Warden.
Okay, so the following is some of the common questions we get, and one of them is, does the Medical Board of California license outpatient surgery settings? The answer is no. The Medical Board of California indirectly oversees outpatient surgery settings. And how does it do that? The board approves the agencies that accredit the outpatient settings. So the next question is who can operate, manage, conduct, or maintain an outpatient surgery setting? And that is an association, a corporation, a firm, partnership, or an individual person. And that's specified in Health and Safety Code, Section 1248.1. Who's exempt from accreditation agencies? An ambulatory surgical center that is certified to participate in the Medicare program, any clinic conducted, maintained, or operated by a federally organized Indian tribe or tribal organization, and any clinic directly conducted, maintained, or operated by the United States. Any primary care clinic or surgical clinic licensed under Section 1204, and any hospital facility licensed as a general acute care hospital. Outpatient surgery settings where analytics anesthesias are administered in compliance with the community standard of practice and doses that do not have the probability of putting the patient at risk for loss of life or protective reflexes. The powers of the board. The board approves the accreditation agencies. The board may inspect outpatient surgery settings and shall investigate complaints. The board shall evaluate approved accreditation agencies not less than every 3 years. The board may terminate the approval of an accreditation agency, and the board, under certain circumstances, may seek injunctive relief. The board grants approval to an accreditation agency upon the accreditation agency submitting an application and the necessary fee, the required supporting documentation, and then board determining that the materials submitted indicate that the accreditation agencies meet the minimum requirements set forth in relevant sections of the California Health and Safety Code and the California Code of Regulations. Outpatient surgery setting accreditation requirements. Outpatient surgery settings must meet the minimum requirements pursuant to Health and Safety Code 1248.15 and California Code of Regulations Section 1313.4 to be eligible for accreditation by a Medical Board of California approved accreditation agency.
And I know, Madam President, members, I know you all want to hear from don't want to hear from us and want to hear from the accreditation themselves. And it's my understanding that all four are present here and will be coming up shortly. I think it's important to remember that our statutes speak to the agent that the outpatient surgery center must be accredited or licensed or fit into one of those other statutory classifications. We, as a medical board, in the absence of a statutory obligation or a statutory mandate, do not rank these agencies about who's the best and who's the worst. Just like we do not rank physicians. If you call up the medical board, we won't tell you who's a really good physician. If you call up the state board of California, they won't explain what my score was on the state bar exam and how I miraculously passed. Okay? They are equal. Okay? If someone would call and inquire which agency, which accreditation agency have been approved, we would say 4 have been approved. An outpatient surgery center may choose one of the 4 approved to become accredited by one of the 4 approved agencies for whatever reason. They may have an advertising plan. They may have a business model. They may have a business plan. They may have economic considerations. They may have some other consideration that the board is not aware of. But our inquiry essentially stops when we say, is this accreditation agency approved? And if the answer is in the affirmative, essentially that meets our obligation. That meets the statutory obligation to perform procedures that require that level of anesthesia in an approved, accredited setting. Because, like I said, from our perspective, if the setting itself is accredited by one of our 4 approved agencies, then it has satisfied the statutory obligation. And with that, I will yield to any questions, and if you don't want to hear from us, I suppose we'll go and hear from...
Yeah, so are there, Mr. Serrano-Sewell and Ms. Yaroslavsky?
Thank you. I actually do have questions of staff before we hear presentations. And that has to do with, just broadly speaking, and I think they more pertain to legal, but they're also staff questions. So this is a window right now in which staff was reviewing their applications to be an accredited agency, right? That's my understanding. We're going through this application process right now.
We're going through the renewal process.
The renewal process right now, for which they file an application, for which we can deny their renewal status if, in fact, they have not stated or articulated a plan that is responsive to the information that we need. And I'm speaking to the website now. The information we need to put on the website. That is one of the things that they have to do, but it is an important one. So my question is, it's a statement, right? If we're not getting this information, and we've acknowledged that some of these accrediting agencies are in noncompliance. We've said that in a sunset report. Right. So what are we going to do through this application process to be very direct to the accrediting agencies that within their application, if it is insufficient or it doesn't get to compliance, we won't approve them, or we'll find them in non-compliance and begin that process to revoke their status.
Again, I don't know the procedural aspect of where we are. From a purely legal perspective, if in fact the board wanted to terminate on an agency's approval, we would of course have to have cause. That's also an APA-style proceeding. So it would be the same thing, probably the accusation being the mechanism or the failure, whatever document indicating that they are not in compliance, and then they would have a hearing, the usual process set forth in the Administrative Procedure Act. So if I don't know the bulk, I don't know the scope of your question.
Well, it has to do with if the agencies aren't giving us the information that we need,
Okay.
for whatever reason, but they're not.
Okay.
And we view that as a problem. And going forward, we state clearly, if you don't give us the information we need, we view that as being in noncompliance. Therefore, we will issue a noncompliance letter and begin the Administrative Procedure Act to revoke your status as an accrediting agency. And I would think it's through this application process that we can be very clear what our intentions are. Is that your understanding of the process as well?
The renewal process just went out to the accreditation agencies within last week. In that request, it is asking for them to provide us all the information that's required, and then for the missing information that they have, to give us a timeline when that is. We have given them a guideline of when that timeline we expect them to do that, so that we have that. We also are going to try to assist the agencies in providing us with that information by identifying what each agency is missing from each accredited center. We have run into a little snag in doing that, so we're going to try to get that out to them, we hope within next week. But we're doing these steps to get that information. They have been providing us information slowly and more, but we're still not in total compliance, as you stated. And we're trying to get to that total compliance.
Well, when's the timeline to get in total compliance?
Well, as I previously said, we're asking for all the information to be submitted to us by the end of May.
So you can't
or a timeline when they think they can have that, so we can evaluate whether or not we believe their timeline is reasonable or not. But that's the process that they go through for renewal is sort of lengthy, and we have to give them enough time to fill out the information that they would normally provide us, in addition to the stuff that is required as the passage of SB 100, which is a lot of the information was not collected previously, and so they've been working on collecting that information. So we're in that process, and we'll be working on that, and like I said, we have decided that we might try to help them identify that, but when we tried to run our report from our system, there was a flaw in it. So our ISB people are working on that with our licensing manager, who's in charge of overseeing outpatient surgery centers. So we hopefully will be able to provide that information to them, which will help expedite their providing us the information. Our goal is to get it as quickly as possible, and that's where we're at.
I'll stop because my other colleagues want to talk. Okay, but so you just saw my position, right? My position is full compliance sooner. The laws have been in the book for some time. I understand snafus need to be worked out, but I'm putting the pressure on because really, once that approval is given, you've got to walk through the process to take it back, versus just denying the application because they haven't submitted a reasonable plan to get the information.
They're already accredited, so it's not as a new person applying. They still have the renewal process is to see if they're still complying.
All right, okay.
So it's a little bit different, but it still requires, we would have to notify them that they don't meet their compliance and that we're disapproving them, and then they have the administrative process to appeal it.
I understand that. That's fine.
Okay.
That's available to anyone.
Ms. Yaroslavsky?
So I have a couple of questions. One question would be, I understand that Health and Safety Code has the language in it of what allows someone to be accredited. Have we ever taken a look at that, or should we be taking a look at it, or who should take a look at it to see if it meets today's needs and necessities, number one. So should we have the expectation of uniform standards of being the minimum standard, and at what level? But I don't know what's in the Health and Safety Code. I don't need to know what's in the Health and Safety Code. But I know that it was done a long time ago, and my concern is that with the practice as it has evolved, of using surgery centers, my concern is that it may in fact not be meeting the needs. So to the next question, you can figure out that answer. My question is, if a new company were to come into business and decide, I want to do this, I can evaluate as well as the next person, there's money to be made, how do we determine what should be, if they can do that, what in fact should be the criteria that allows that entity? The only place we have to hold them on is on that renewal process. So how do we know today that those renewals that are going on to existing, how do we know that we're not just keeping to kick that can down the road, that in fact that the laws that are on the books are up to date and they apply to the needs and meet the needs of today's community? Maybe that's the...
Well, to answer your question about whether somebody wants to become an accredited agency, there's an application process for that also with a fee, and all that requires a complete application, lots of supporting documents. Once staff would review all that, determine whether or not they think staff would be appropriate for staff to bring it to the board for recommendation for approval, that would be a board's decision at that point in time. Renewals are done a little bit differently but that's still an application process, unlike a personal license,
right,
where it's not an application process. So that's where we're at. Each of the accreditation agencies, the Health and Safety Code states the minimum requirements, and they're pretty detailed. But each agency can add to that if they choose to, depending on the type of surgery center that they're accrediting. It's the responsibility of them to make sure. It's also the responsibility of the physician who's using the accreditation agency to ensure that the facility meets the needs of the patient's care and the surgery procedures that they're doing, because ultimately the physician is the one responsible for the patient's care. And so it would be unwise of a physician to go do a surgery in a center that is not set up to do that type of surgery, because the outcome would probably be not good. And they're not only are they jeopardizing the patient, but they're jeopardizing their own license.
So the issue is how to not be reactive and to be more proactive in ensuring that these entities that are doing the accreditation that we approve are in fact at a level of what needs to happen. That's my concern. And start at the beginning.
Ms. Whitney wanted to comment on the body of regulation that stipulates the minimum standards.
We have two things. We have legislation that sets the minimum standards, and then we have produced regulations based upon that. In Sunset Review, we didn't actually go through all of those areas. We looked more at the program itself and not at the underlying law and regulations that sets forth how one could be accredited. So that is something that staff could look at, but we haven't examined that. I do know that the legislature examined it 2 years ago when they enhanced the law with SB 100.
And that 1248 is in this material, is that correct?
That is correct.
Could you
Yes.
point out the pages so?
Is there?
It's in the section prior to the 4-agency presentations.
Yeah. So starting with page BRD 4-3, it talks about the different sections of law, but specifically on 4-4, it's the minimum standards that one has to have in an accrediting agency as set forth in Health and Safety Code. And some of the other requirements then follow that. So those are all laid out for you to review.
And the actual Health and Safety Code language is in, starts at BRD 4
48 starts at 4-15.
To 4-27, and then there's the California Code of Regulations follow that. Now, the board does have the authority to evaluate regulations, and we do have regulations, and that is something that would be something the board could look at as is, do our regulations meet today's standards? And that's something that staff could look at.
Okay, and Dr. Gnanadev,
Thank you, Madam Chair. My question is on quality control. Okay, so we have 4 agencies who do this. Have we really looked at and see all the complaints you get, all the news media who are accredited by who, and how do the physicians pick which ones? I mean, I'm looking at the renewal application. There is very little about quality control there. How do we know that they're doing a great job? Their job is to make sure that there is a certain quality control at the centers. Our job is to make sure that there is quality control with the agencies which we designate to do to that accreditation. So what kind of process are we following to make sure that all the agencies are doing what they're supposed to do?
Well, right now, the renewal process is set up to do what you would call a quality review, and that is to see if what they have is meeting the requirements of law, because they provide us a lot of documentation. I know that you look at the packet and it doesn't look, but they're going to be providing us a lot of information. We have the right to ask for more. We can do that. But the bottom line is they have to meet the minimum requirements to become an accreditation agency, and they only have to accreditate a outpatient setting to the minimum requirements. I don't believe any of them probably just do the minimum requirements. I believe they all go beyond that. And we'll be finding out that when we get the material. So
maybe that's where we should go with this.
Yeah, just to take it further, you get a complaint. One of our investigators goes to this surgery center, finds these rusted instruments, dirty operating rooms, and it was accredited by one of our 4 agencies. So what type of process do we have to really be on that agency? That's what I'm concerned about. I mean, normally, as a physician, the way my thinking is, all right, so I got a surgery center. Let me see who is the easiest way I can get accredited with, rather than how difficult one can be. Usually, physicians know which agency will be a little easier than the other. So we need to have some type of a serious quality control, and if we find something, we need to be on those agencies, not just every 3-year renewal application. That's what I'm coming to.
So maybe the thing to do is to hear from the agencies and to ask the agencies as they present how they address problems that occur. And then tomorrow, when we talk about the program, we can look at our own accountabilities around the accreditation process. But I think rather than asking Kurt, what's his name? Right, the soon-to-be former medical board attorney. Why don't we, I think, given what time it is, I think it would be helpful if we hear from each of the agencies and then save our questions for the agencies, and then tomorrow, if we have overriding issues around our accountabilities and how we exercise them, we can deal with that tomorrow. So unless I hear I'm sorry, I cut you off. Yes, go ahead.
What is that? I just learned that the ACS, which is exempted if they are certified to participate in Medicare programs, who accredited them? Medicare's own accreditation program?
I believe they're accredited by CMS, aren't they?
They're, the people who can accredit a Medicare program are approved by CMS.
Right. So is any one of these 4?
Yes.
Three
of us are.
3 of them are.
3 of them are.
So 3 of you go through 2 accreditation processes.
Correct. So Medicare has already vetted us before you even have to.
Right. Question I ask because I think usually Medicare is pretty tight about that.
They're quite tight.
The second is that I'm new to the board. Is that something that first time we deal with, or we have do the renewal We have done the renewal like 2 years ago, 3 years ago.
The last renewal was a little over 3 years ago, because we're running a little late on the renewal, so.
I think what we can learn, because I can see the practice environment changing, the number and type of procedure which is being done is changing every year. We can look at the data from the first round that we have. We can actually be more proactive, asking questions for agency to supply data for us, rather than for them to give it to us, we look at it and say, oh, we are not happy, we want more. I think we drag on more.
Well, during this renewal process, we actually have to collect more information from them because of the passage of SB 100, so.
So in some ways, this is a new accreditation because of what SB, is it, what you're saying is this is a different accreditation?
Well, the SB 100 added additional requirements, so.
Okay. Can I move to the agencies? Okay, great. And we have 4 agencies. Thank you all for coming, by the way. We're going to start with the AAAHC. Ms. Kurtz and Ms. Way.
Thank you.
And I just, to all 4 agencies, I was struck as I was going through your presentations that none of you provided data.
Yeah.
You described your process, but I didn't get a sense reading through here of, any of the statistics around how many agencies you accredit, how many centers and so on. So if you could
We have
incorporate.
8 million procedures to present.
Huh?
We have 8 million procedures data to present.
Oh, okay. Great. How long will that take?
They should all be at the same table.
Okay, go ahead.
Okay, thank you. Yes, I'm Carolyn Kurtz, the General Counsel and Vice President of Government Affairs for AAAHC, and with me is Mary Way, the Assistant Director of Accreditation Services. And we appreciate being invited here to California. Obviously, coming from Illinois, we're happy to be here. And we understand the concerns of this board. We want you to know is that AAAHC has been accrediting ambulatory healthcare organizations for over 34 years, and in fact, close to 35 years. We are the largest accreditor of ambulatory healthcare organizations in the country. We are deemed, as was just said, by CMS to do Medicare certified ASCs. In addition, we are recognized in every state that mandates accreditation for both licensed ambulatory surgery centers as well as office-based surgery centers. We understand that in the state of California, there are primarily non-licensed ambulatory surgery centers and office-based surgery centers and all different kinds in between. But in other states where there's a clearer differential, AAAHC is in fact recognized in every state. So AAAHC, the mission is to promote its position as the preeminent leader in developing standards to advance and promote patient safety, quality, and value and measurement of performance for ambulatory health care through peer-based accreditation processes, education, and research. And we did bring a copy of our annual report, which goes through more specifically numbers and goes over some general things about our organization in addition to what I'll be going through today. But with that said, what I want to explain about AAAHC is that we have 18 member organizations who represent providers who practice in the ambulatory arena. And those include the Ambulatory Surgery Foundation, among others, the American Academy of Dermatology, ACOG, ADA, AORN, and ASA. But there are 18 total. And they actually appoint the members to our board. Then we have primarily 3 committees that run the accreditation organization. We have our standards committee, which each year publishes standards for revision and in our standards handbook. These are published for public comment, and then they are approved at a November board meeting as final for the year. So as the discussion was about the minimum standards that are contained within the California law, this in fact includes your minimum standards as well as all of the AAAHC standards. We also have a committee which oversees the surveyors. There are about 345 AAAHC surveyors who are primarily part-time employees of AAAHC. They are active in the ambulatory healthcare environment. AAAHC provides the training through the Surveyor Training and Education Committee. They're retrained on-site every 2 years. They go through annual retraining through webinars for the standards and are trained as needed as developments occur in the ambulatory healthcare environment. And then in addition, we have our accreditation committee, which is a board committee which approves the decisions for the accreditation of organizations. Oh, sorry. So basically, we wanted to go through, I wanted to give you that background before we went into describing the process that we go through. And then we also want to address, again, because we do, as many of the other accrediting bodies here, operate in the 50 states as well as for the federal government, that we wanted to go through specifically what we do in the state of California. And we do tailor, again, depending on the state requirements. We have very specific requirements in certain states for certain programs. So in California, we have very detailed requirements for our California surveys, and we've been doing these surveys since the inception, as was stated in 1995, of your law requiring accreditation of outpatient facilities. So we do have quite a history in this, and our surveyors are well trained in doing the surveys within the state of California. So basically, before the survey, let's see what, oh, sorry, let me go back. Our organizations will, and again, in terms of choosing accrediting organization, as you all pointed out, there are 4 that are approved. And what we basically find is that organizations will choose an accrediting organization based on the comfort with the culture of the standards. How are the standards written? Does it appeal to them? They talk to their peers. They find out who went through a process. Oftentimes it's, an administrator in an ASC has gone through the process with one of the accreditors and moves somewhere else and says, you know what, I'd like to take the organization through that process because I'm familiar with it. I enjoyed the survey. The 888C survey, we like to think, is educational and consultative, that we really help our organizations try to continuously improve the patient care that they're doing. And that is very important. That's paramount to our mission. So it's a continuous quality improvement mission of 888C. And we like to think that the organizations choose us, they wish to partake in that. So with that said, if they've chosen 888C as an accreditor, they come, we determine their survey eligibility. That's sort of the first point. And they have to basically qualify to have a survey from 888C. They have to be providing healthcare services basically greater than 6 months prior to a survey in order to ensure that they are in fact even going to be able to get a 3-year term of accreditation if they achieve accreditation. We do have an early option survey for organizations that have been in existence for less than 6 months. And again, because in California, your organizations cannot do higher levels of anesthesia without being accredited. If you have a new organization, for example, a gastroenterology office, some office where their livelihood is to bill these procedures, they need accreditation sooner, otherwise they can't operate. So we do have an early option survey, and this is the case in other states as well, where a surveyor will go on site and the organization will have all the policies and procedures in place. They may have all of the things set up, but they don't have the history. So as Mary will go into greater detail about what that survey looks like, not everything can be done in the level of detail that we would like to see. So with that said, if an organization is in operation for less than 6 months, they will be guaranteed to have an interim survey either at a 6-month period or a 1-year period, again, depending on how well they did on that first survey. Then, obviously, we require that they're organized and legally constituted entity. And again, that depends on the state in which we're looking at. Corporate practice of medicine concerns in certain states, including yours, they have to be formed a certain way. And then licensed by the state. I think it's very interesting to note, and again, I realize this is unique to California, because really virtually every other state has the ability to license ambulatory surgery centers in greater numbers than we see in the state of California. So you do have a unique situation here. In terms of numbers, we looked, it was interesting, we have about approximately 540 total organizations that we report to the medical board. So in other words, those would be the ones that are using anesthesia at a level significant enough that they would need to be reported. We also accredit primary care and other types of organizations. Indian Health, they don't get reported to your board. But there are 540 total. Of those, we have Medicare certified ambulatory surgery centers, and there are about 340 of those. Of those 340, which are certified Medicare ASCs, we have in our deemed status program, in other words, they went through 888C to get that Medicare survey done, they didn't go through the state. We have about 140 of those. So what's left really in terms of organizations that are under the sole jurisdiction, as you will, of the medical board and of under 888C, by virtue of that, there are about 200. Then we also require that the organization provides the healthcare services under the direction of specified healthcare providers, an MD, a DO, a DDS. And again, what we find very interesting with this part of our eligibility criteria is that there are increasingly, as we've seen over the years, very innovative structures for how physicians practice. And I'm not sure, how where you all are of this, but we find it when organizations apply for accreditation, we'll see that there may be different corporate entities that they're trying to divide perhaps where they bill. And again, some of this is done because insurance companies may have said to an organization, you can get a facility fee if you form a separate corporate entity and get that accredited. But if that organization is not providing health care and that organization does not have the appropriate medical direction, we won't accredit that organization. But that also, the environment is very complex out there and probably will only get increasingly so. Then we look at all of these other requirements. And I just want to highlight especially the last one, acts in good faith in providing information. And this is throughout the accreditation term. And this is very important in terms of the disclosure of the organization, what they tell us in that application. And Mary will go into further details about what we require for California organizations specifically. But that is something, obviously, that we take very seriously. We make sure that our organizations understand information that they're giving to us. They must attest to that, the fact that it is truthful, and it must be updated. And our organizations know that if that is not the case, they, in fact, can be non-accredited for that. And now I'd like to allow Mary to go a little more into the survey process.
Hello. Specific to California outpatient settings, we did have to amend, as was stated previously, our application for survey in order to collect some of those details that SB 100 required. Now, some of those details included specific individual owners, their medical licenses, the percentage of ownership, contact information, et cetera. So we did have to amend our process and our application, actually, to collect that information. We also ask organizations to identify what level of anesthesia they're providing so that we can be sure that whether or not they meet that threshold for your oversight. And we also now ask them, actually we ask them twice. We ask them in the application and we ask them during the on-site visit to basically attest to whether or not they've ever been denied accreditation through any of our other AO counterparts. They have to, if they have been denied accreditation, provide us a copy of the survey report, which we then have to review and also then review on site with them. So we have asked organizations to provide more information in greater detail for the state of California. After an application has been received and after it's been reviewed for completeness, we do schedule an on-site visit. We work with the organization to schedule an optimum time for survey. And the reason why we do this is to make sure that there's a case to review. We like to observe a procedure during our on-site visit, and that lets us see the policies in action. It lets us, it lets the organization show how it's implemented, for example, its infection prevention program and all of those other factors. And as we've moved on to our on-site visit, let's go on to our on-site survey. While we're on site, like I said, we review documents related to the organization,
specific to what we require in our standards. So we ask them to have standards related to credentialing and privileging, or policies and procedures related to risk management, quality improvement, peer review, infection prevention, as I've mentioned. And we review all of that during our on-site visit. Now, our on-site visit isn't just about document review. We do, like I said, review a case. We observe a procedure. Our surveyors conduct interviews with the staff to determine understanding and thorough implementation of these policies so that we can make sure that, you know, we're not just accrediting a set of paperwork documents, that we're in fact accrediting a whole organization. And that's what we like to think when we go out to accredit a facility, that it's not just a place or a location. It's also the people in it. It's the providers giving care. It's the front staff. It's, you know, the back staff. Our surveyors, well, actually, I also have to mention that prior to the survey, we ask our organizations who have applied for a survey to post a notice of accreditation 30 days leading up to the visit. The reason for that is to allow patients, employees, members of the public, whomever, to notice, oh, this organization is going through a survey, and to know that they are allowed to speak to our surveyors if they have any concerns, and they can speak confidentially to our surveyors. In fact, we have had that occur in some of our surveys in California, specifically. But that allows members of the public to have an impact in the accreditation process. Okay. All right, surveyors will also, during the on-site visit, look and make sure that an organization is complying not only with the standards as they stand at that time, but that they've continued to comply. So in cases where organizations are renewing their accreditation, we look at how they've complied as our standards have changed. We also look at how they've corrected any deficiencies that might have been cited during the previous visit. Our surveyors, again, observe a procedure to identify how the policies have been implemented, and our surveyors work very consultatively with the organization, highlighting any areas of concern and making sure that the organization has the appropriate structure, mechanism to implement corrections for those areas. Specific for our California organizations during the on-site visit, do you want to talk about? I'll turn it over to Carolyn.
And I apologize, we garbled one of your sections in numbers here. But yes, we do. Our surveyors are given the requirements of, obviously, of the California statutory requirements, which, you know, include, again, your standards, which mostly are included in our standards normally anyway, but then the additional requirements such as the posting of the accreditation certificate, the posting that the physician is licensed by the board, all of those additional things that you all have in your law, our surveyors are checking for on site as well. And then again, of course, they are, as Mary said, checking for compliance with any previously cited deficiencies. And then, once they are done, they complete a survey report form, which is sent back to HHHC offices. And again, it's on a California survey. You have a physician MD, and many of our surveys are actually larger, so they may include more than one surveyor in California. I'm not sure the statistics on how they break down, but again, they are scoped according to our scoping criteria for the number of operating rooms, the number of physicians, the number of specialties. So based on that, we determine the number of surveyors, and the MD surveyors are on those surveys. Then after the survey, the surveyors will submit a survey report electronically back to HHHC offices, where basically the HHHC staff go through it for a quality control check. And I'll turn it back to Mary because she works with the accreditation committee and describe the process after that.
Sure. The report then is reviewed by members of our accreditation committee in order to determine an accreditation decision. And that, we have a 3-year term of accreditation, but as Carolyn said before, there are segments of our population that perhaps require more oversight than a 3-year once every 3 years would allow. So that's where our accreditation committee steps in and determines, based on the severity of the deficiencies, if there are in fact severe deficiencies, if either we deny accreditation or if we say, this could be an accreditable facility, but we need to go back in 6 months to check. And we do have those mechanisms. So these interim surveys are scheduled at 6 months to a year. There can be multiple interim surveys. So if they have continued noncompliance and we decide to go back, we can, or we can also remove their accreditation. Let's see. Okay. So the exciting part is the reporting. Every month, we do send a report of the outpatient settings that have previously, or that have been surveyed and a decision has been granted for the previous month. So we send a report to the medical board with these organizations, and in that report, we include things like the specialties, contact information for the facility, and the list of owners that are, the list of the physician owners within that facility. So we do make every effort to include that in the monthly reports, and we have moving forward from that implementation of SB 100. We can understand, though, it does take an incredible effort and amount of time to produce a data warehouse that's comprehensive. And we actually know that we are going through that experience currently with our own internal processes. Okay, so denial of accreditation is reported. There's a requirement for the reporting to be more immediate than in the monthly report. So we do make sure that that happens when we deny accreditation. Also, we do send a copy of the survey reports and the accreditation decision letters to the medical board, and that also happens every month.
And just to follow up on what Mary said very quickly, that you would be amazed at the list of physician owners. So we have organizations that we accredit that have as many as hundreds of physician owners. So this is the type of data that we're dealing with. And that I think is part of the issue. It is quite complicated, and drilling down to all of those individual physician owners is quite onerous. With that said, and then for really during the accreditation term, we expect the organizations to maintain compliance with the standards as they change from year to year. We do provide all our accredited organizations with the handbook as well as any alerts that come out during the time from CMS, CDC, anything that comes about. We do a quality assessment on ourselves as well as on the organization through random surveys, random unannounced surveys, which organizations know they are subject to at any time. We do discretionary surveys based on complaint. And again, the complaint can come from a member of the public. It can also come from a state in which we have an agreement to do those complaint surveys. So there are states, California is one, I believe, which can ask us to go in. If they have a complaint, we will go and do the complaint survey. And then again, as Mary described, those interim surveys for organizations that we would like to see that they have maintained and corrected any deficiencies.
I also want to say that we do require organizations to notify us when a significant change has occurred. So organizations that have experienced a change in ownership, a relocation, merger, or any types of those complex structures that Carolyn previously mentioned, we do expect notification of that throughout the accreditation term, not just at the application or reapplication process.
Okay, thank you very much. And I want to give...
Well, this is a question I'm going to have for all of them, and that is, you said you had about 200 that you report to us.
No, we report currently about...
I'm talking about just to the medical board.
No, we report,
okay.
we report to you 540 because we are reporting organizations that we accredit that are either, they're Medicare certified,
okay,
right, or they're through our deemed status, Medicare came from us.
Yes.
And then those that are not Medicare certified, there are 200 that are not Medicare certified, basically. And so about 540 total that we're reporting to you currently.
And how long will it take I would assume some of that 540 is in compliance. That is to say, we have all the requisite information.
Mm-hmm.
Some of that 540, probably not. So what is your process to resurvey those centers that have not provided all the accurate information? When can this board expect to get all that information?
Well, I mean, I think that, we've been through, and we have been through a similar process in another state, where we, if we're doing a survey and we're getting the application, obviously that's when we get the information. So basically, if you have 3-year terms of accreditation, right, and your implementation had been a year ago, January, there may be some from the very beginning, they were coming to the ends of their terms next year that we didn't have all of that information in our own database. So we do have the ability, obviously, to go back to those organizations and get the information from them.
So I understand it is you don't, if you know that you have inadequate information, you wait until that surgery center is up for reapplication, which could be next week, next year. It depends on when they were first certified.
No, we had the information. For some of the existing organizations, we had the information in our database. Again, understand that it sounds like it's not that complicated, but when you look at the ownership structure, what you get are sometimes you don't get. The ownership may be a partnership, a private trust, and then you have to go down to find the individual, right?
I understand that.
So some of our information on those organizations, we had ownership information. Some of it were physician ownership, and we were great, and some was not. So I can't tell you that we have given you 100% of that group. Can we go back and attempt to, get it from these organizations? Yes, we can.
So you can resurvey them, if you will, or do an addendum to your first survey saying, I need this additional information.
Yes.
Are you guys is that part of your plan right now?
Yes, we can, sure.
No, we can't.
Yes,
I know.
yes.
So is it part of the plan
Yes,
right
because
now?
I believe because we received the, we just received the renewal application for our application to you all.
Great.
So as part of that process, we will do that, yes.
Do you know how long it will take for you to get all that information? So the 540 or so, we have all the information so we can report it on our website?
Uh-huh.
Sure, and we have been reporting on a monthly basis since last year, every owner in the facilities that we report. So usually on a monthly basis, we report somewhere in the neighborhood of maybe 20 to 30 facilities. So if you kind of do the math, then we've reported a portion of that at least, not to mention the baseline reporting we did in the January of 2012 and also in June of 2012. So there has been reports, lists of owners and all of that.
No, but I understand your question is 100%, correct? Your question is when, right.
That's the expectation that,
yes.
Well, the expectation of this board is that we comply 100%
right.
with the law.
No, and we understand that. And certainly, as in other states, again, as I said, we've had this issue in other states. And if we can work cooperatively with you, I think as Kurt's right. If we can get a list, in other words, if we can get a list of what's missing, because again, we submitted monthly, we submitted, right, and so now we've had some, and some of them, the ones that we had that were accredited may have lapsed. So in terms of, really getting you the prime data, it would be nice to work cooperatively. So if they could tell us, you are missing these organizations, then it certainly makes it, much more efficient for us to go back and say, okay, we're going to get all these organizations. So any help that we can get, but obviously we're going to work as quickly as we can to ascertain which portion you don't have the data on, and we'll get the data for you.
Dr. Solomonson and then Dr. Gnanadev.
Well, I liked your presentation, and I like Mary's comment on it's not just a building, it's the people in the building doing the care. As you well know, we don't license to specialty in California, so we rely on credentialing in hospitals to keep me as a plastic surgeon from doing cardiac surgery, in addition to my conscience. That wouldn't allow me anyway, but in addition to that, I wouldn't be privileged to do it. What does your agency do, or accrediting agency, to look at the privileging of the surgeons using your accredited facilities?
Our standards include standards on credentialing and privileging and requirements that they perform their own credentialing and privileging, meaning that they can't just accept or adopt another organization's credential investigation that they did. They have to conduct their own. So they can do that through a CVO. They can do that themselves, a credentials verification organization, and they can do that, or they can do that themselves. A lot of organizations, depending on how big or small it is, will choose one or the other. So I hope I'm answering your question
Well, I mean, the CBO I'm familiar with is that they went to medical school. I mean, that's kind of what I know about, like the FSMV's credentialing, but I guess I'm wondering about.
They can't hear you.
Oh, I'm sorry. I'm wondering about, for surgery, what sort of proof a given provider would provide to an agency that they are trained to do that surgical procedure? I guess I'm just beating around the bush. Do they have to be board certified in a specialty?
We do not require board certification
Or eligibility. We understand not everyone immediately, obviously, coming out of training will be certified. So board eligibility is the level?
We don't actually have a set specific requirement. We ask organizations to identify their process by which they credential their providers. So they have to present to us, how their governing body accepts their clinicians, accepts their providers, and privileges those providers to provide services at that center.
So each of the ones you accredit might have a different process?
Correct.
Interesting.
Right, and also then the surveyor, when the surveyor goes on site, the surveyor pulls these privileging credentialing files. And then it's also expected in the quality improvement. So if you were, so they basically go through the organization presents its policies, right, for doing this. The surveyor randomly pulls the privileging credentialing files of, however, depending on the size of the organization, they randomly pull and see what the organization has done. Did they do what they said, how they would privilege these people? And then they'll look at if they have adverse events. There's an adverse event reporting requirement that they have to have that system. So they'll look and see, is there a provider who has had adverse events? So it all ties back into the quality improvement. So if there's an issue with the privileging, that's how it comes up. So it's all tied together.
Yeah, and we also expect them to have a robust peer review program. So they have to, even in a solo setting, get somebody to peer review their cases so that they can make sure that all of their set criteria are being met. But they do set their own criteria.
And I want to say to the other three accrediting agencies, those two questions you will each be asked, so.
Yeah, I don't want to keep you, right, but peer review in a solo setting is also an intriguing question with HIPAA requirements. I'd be curious how that happens, but I don't know that we have time for that.
Dr. Gnanadev?
You mentioned about random surveys. How often, what percentage of surgery centers get random surveys, and how often are there surprise visits than scheduled visits?
They're always surprised. They're always very surprised. Yeah, so it varies between, I'd say between 5 to 10% of organizations.
And if you find something, do you report that to medical board?
Under your law, yeah, sure, we certainly do.
Even though they're certified by you the last time you went for accreditation, but in your surprise visit you find deficiencies. And do you send that report to the medical board immediately?
Yes, because that's a survey report. Yes. That generates a survey report.
Those survey reports generate the most questions.
Yes. Yes.
Dr. Ip?
I have a question that, accredited for 3 years, to me, it's good and bad. It's a saved labor, but things change a lot in 3 years. I know you're unannounced 10%, 20% of the time. Do you require your center that you accredit give you like quarterly statistic as far as number of cases, variety of cases, and infection rate, admission rate to the hospital, etc.? The reason I ask is that when you first, going for 6 months and you get a credit and they start marketing, they may be doing 5 cataracts a day, and then 6 months later, a year later, they're doing 15 cataracts a day. And there's a question, do you know that? And are you tracking those statistics to give you some warning whether you need to go back again? For example, if someone doing 20 cataracts a day, you're going to wonder, do they have enough time to sterilize the rooms, etc.? Are there things that, this question to all the agencies, is there things that you do to catch the error that can be made in the process growing? 3 years to me is quite a long period of time. And the reason that your organization, we also, the consumer, we like us to tell them. So we go to that center. I know you're reporting on the ownership, which is not a big issue to me. I'm more concerned about the outcome and the quality. as a surgeon, I'm seeing people doing laparoscopic cholecystectomy in the surgery center. I'm seeing 20, 30 colonoscopy done a day. Are we doing our job to make sure that those quality outcomes are acceptable? I mean, do you have mechanism for that?
I think that's a great question. We do track statistics of, how many procedures, how many adverse events do you have. We do track that through our application and our renewal application. In between, we do ask our organizations to tell us when they've had adverse events. We also monitor the media for any adverse events that hit the stage, so to speak, and we're able to act very quickly to either survey those facilities that have those unfortunate outcomes, and we do take those to our accreditation committee directly when we find that there has been.
Those are after the fact. You don't want that to happen.
It is after the fact.
Yes.
Yes. A survey is a point in time. So it is very difficult for us to be around 24 hours a day, 7 days a week at each facility. That's not, I'm not intending to say that an excuse. It's more an explanation on, what the, limitations of the accreditation processes could be.
Ms. Yaroslavsky?
Just turn my question into suggestion, so.
Yes.
Okay, so I apologize, but I'm going to have the same question for all of the people that are presenting. And I'm going to suggest that you address these issues, because our concerns are, we understand that you are the entities that accredit the surgery centers. This is something that this board was not aware of prior to, let's say, 2 years ago. Trust me on this one, just accept it, okay? So now that we know that our responsibility is in the oversight of the accreditation entities, we take our job very seriously. This is a very serious situation. So there's things like what we want to know, assuming that we believe that the minimum standards are appropriate, and I'm not there yet. Understand, I'm not there yet. But I want to know when bad outcomes happen, when I understand bad outcomes can happen regardless of the preparation and the ability of the doctor. For good things happen to bad things happen to good people. Remember what happens to whom. So I want you to understand, I understand that. So I'm directing the question now to you, but I think that every one of these accreditation entities that are coming before us today have to explain to us what happens when you find something wrong happening. What is your process by reporting? Who do you report to? Do you have the ability to shut down a facility? What is the timeline? What is the time? No, seriously, because it's not happened. So I'm not saying you haven't done it, but the media knows and we don't know.
Right. No, we first and foremost, we have no ability to close down any organization.
So what happens when you find out that one of your surgery centers has done something that would cause an issue to need to be further
So your
dealt
only
with?
tool is to withdraw.
Withdraw the accreditation,
Yes.
correct.
You withdraw do you make a report to the police department, to the Attorney General's
No,
office?
as a matter of fact,
The LA Times?
in states where we have a reporting requirement, because, and understand, I guess, let's go back 30 years at the beginning of this. I think accreditation, again, was a peer review process that was entered into, voluntarily by organizations that were interested in quality improvement.
Good.
And this was, right, and this is what it was, and this is how it began. Now, over the years, clearly, we've become quasi-regulatory. But with that said, we don't have regulatory powers. So what we do is, and as part of the peer review process, the idea was that what the accreditation organization saw in the accredited organization that invited us in was actually privileged, and that we wouldn't report out because, again, it was like a peer review in a hospital. The idea was to openly discuss and have quality improvement based on those discussions and what was seen. And that was the original idea of accreditation. Now, with that, we've crossed into these areas like in California and many other states. But where the state then says, or the federal government, such as CMS, says, we want to see those reports, we want you to report those events to us, We certainly do, and we report to you. So if we are going in and we have an adverse event, we go in and we see something, we report it very quickly within the time that we are told, different in different states, different to the, everyone has their own rules, but we report it as we are required to do, yes.
Okay, so, and just to clarify, you can pull an accreditation, you report to the medical board, who can go after a physician's license for the physician who was involved in the event or can begin discipline process. And for a licensed facility, the Department of Public Health can pull a license.
Yes.
Which is, it is then an unlicensed facility, which essentially shuts it down.
And CMS, of course, if it's the Medicare certified.
They just won't
They can yes, go in as well, right.
Right, so those are the penalties. I think we're going to need to move on. Sorry, but as you can tell, there's a lot of interest among our board.
Thank you.
And we're going to move to the quadruple A SF. Dr. Jeffrey Keys
Dr. Keys.
and Mr. Terranova.
Right.
Okay. Take it away.
All right. My name is Tom Terranova. I'm the Director of Accreditation for Quad ASF. I have Dr. Jeffrey Keys with me. He's the President of our Board of Directors. I'm going to be very brief and touch on the accreditation process and the standards because Dr. Keys has some really powerful data and things like that he'd like to talk about that I think go to Madam Chairman's question about data and quality assurance. Our mission is patient safety. Clear and simple, that's what it's always been since 1980 when the organization was founded. Again, this is a somewhat of a peer review system. It's clinical surveyors trained on how to survey, but they have clinical expertise in the settings in which they are accrediting. We do require 100% compliance with all applicable standards. So anything that's required of a facility must be answered yes. If something's not applicable, there better be an explanation as to why. We do require board certification or eligibility in the specialty being performed in the facility. We also require demonstration of hospital privileges for any procedure being performed in the facility. Those are non-negotiable items. Statistical data does indicate improved outcomes. Right now, there are 27 states that either require or have guidelines talking about accreditation either for the ambulatory surgery center or the outpatient setting as you define it here in California. Quad ASF, just like two of the other organizations, is recognized in all of them. We're also a CMS deeming authority. The accreditation cycle is pretty simple. There's a 3-year cycle. Intervening years contain self-evaluations, really to educate the facility as to changes. Like you said, things change over time. There's also on-site reinspection after that. We don't allow reciprocal inspection processes, so you can't trade off inspectors, et cetera. Also, within this system, every 6 months, every physician in every facility is a mandatory report of all unanticipated sequelae and 6 random case reviews, including the entire universe of cases conducted. That's a lot of what Dr. Keys is going to touch on, so I'll stay really outside of it. Those are our accreditation programs. We actually have 6 programs in the United States. 3 of them are Medicare-deemed programs, and then the other 3, which would be surgical, what we call procedural for non-sterile procedures, and then oral maxillofacial surgery. So there's a wide variety of facilities that we're accrediting here in California and in all 50 states. Everything in the Quad A process is dictated by the level of anesthesia being provided. Quickly to touch on the process, you can see the meat around it that's done in dialogue and in collaboration with our staff, but the real big portion is the on-site inspection, which involves walkthroughs, chart reviews, some personnel review, policy review, as well as open-ended questioning with the facility staff. To quickly touch on the areas of the accreditation process and the standards, the sort of non-Medicare accreditation programs have 9 areas in which the standards touch, ranging from anesthesia to general environment, operating room, recovery room, PACU, et cetera. To quickly touch again on the surveyors, our surveyors are all clinicians. Ideally, we try to have the clinicians practicing in the specialty they're inspecting. That's not always the case, but they're still clinicians. We do have a QA process as well. 5% of all facilities are receiving a validation survey, what we call a validation survey. It's unannounced, and it's within a very short time of their routine survey. We also reserve the right to go in as often as possible as often as necessary to ensure 100% compliance with the standards, and reserve the right to go in as many times as needed. With that, again, the big thing, the big draw to this presentation is Dr. Key's discussion of our peer review system, so I want to turn it over to him, and then we'll take any questions you have.
Just a quickie, the number of facilities you accredit in California?
In California, part of our reporting is 282 facilities.
Well, thank you for the opportunity to present today. And, the gist of the question, as I see it, that you're asking is how do we do what we do? And I think I wanted to start with the fact that our board of directors is made up of professors from most of the major universities in the country. Stanford, past chairman of the Department of Anesthesiology from the University of Chicago, USC, across the country, representatives from the Association of operating room nurses, and some lay people. And that board of directors establishes committees to do some of the things that Tom has laid out already, namely the different areas of accreditation that follow the patient through the entire process of surgery. And what is that process? The process is the preoperative, intraoperative, and postoperative management, the management of the operating room itself, the management of the associated areas where the patient matriculates through the operating center, and just about every aspect of operation of care that is delivered. We are able to put surgery centers on probation, and we're also able to rescind accreditation based on their performance. The peer review program, which is of the greatest importance, was established in 1999 by way of the internet. We now, as Tom mentioned, collect every single sequelae all the way down to a patient complaint. And we do the random case reviews so that we have a numerator and a denominator. And what do I mean by that? Well, we know every 6-month period how many cases were done in that facility by all the doctors in the facility, and we know all the complications that occurred. So we're able to take and extrapolate the total number of procedures done in quadruple ASF facilities and compare them against the number of complications. We have 8 million procedures, and what has that told us? Well, first of all, we've had, in 8 million procedures, about 113 deaths. And we first reported on this in 2004, and the statistics are consistent, about 1 in 50,000. But we need to take a look at why the deaths occur. The majority of deaths occur as a result of pulmonary embolism, the same as with all surgeries in hospitals. We also accredit people who are doing vascular access for renal patients. All deaths have to be reported within the first 5 days of occurrence, and some of these patients have their deaths occur unrelated to their operation in the surgery center. As far as infections are concerned, of the 30,000 sequelae, we had 3,000 infections out of 8,000 procedures. That's an incidence of far less than 1%, far better than any hospital has ever reported. We have had nobody die from an infection. We have had 300 patients admitted to the hospital for infections, all were resolved. So I think what the medical board's really looking for is accreditation a viable solution to safe patient care? And I think the answer is yes. And how do you demonstrate that? Through statistics. It's the only way to demonstrate it. So in conclusion, with all of the information that Tom provided for you, I think we are monitoring our patients' care in the best possible way, and I think Medicare has recognized that. Right now we are creating a data hub for all of surgery, not just our own organization, and we're banding together with other surgical specialties to provide ingress and egress of data to medical boards, specialty societies, to improve patient care and to improve evidence-based medicine, which is the new, most important aspect of care that's present in today's environment.
Great, thank you very much. So I'm going to ask Mr. Serrano-Sewell to ask his question. Dr. Salmonson,
Sure.
if you guys can remember the question.
You recall the question, or what I was trying to get to, and maybe I'll ask it better as we proceed. But there's a lot of statutory requirements that this board is required to report. Right. We want to make sure that we have all that information on our website. So we rely on you, the accrediting agency, to provide us that information.
Right.
I've heard varying explanations as to why we don't have it all.
It's very simple. Okay.
So my question will be, after your explanation, or as part of it, how long is it going to take to get all that information
All right.
from your accrediting agency.
I just found out about this meeting a few days ago, and as president, I wasn't quite sure of what did you really want. And I looked into this issue because I found out that you didn't have all the information. You have the majority of it from us. You have probably 95%. There are probably a handful of surgery centers who have not complied with sending us that information. They just received registered letters that they need to comply with that within 5 business days, or they'll be put on probation.
I like that.
And that's it.
Thank you.
Okay. And Dr. Solomonson, I think
your
your
you
question
covered it.
was answered.
The credentialing of the physicians, the surgeons, you may want to just emphasize that you have a standard, universal standard. The individual center doesn't set their own.
Let me make one thing clear about patient safety. This is not the wild, wild west, although sometimes it behaves that way. You should not have dermatologists doing complicated plastic surgery procedures they were never trained for. And as a result of that, we insist, I'm going to reiterate, we insist that you only operate within the spectrum of your academic and credentialed training. So if you're a board-certified plastic surgeon, and even if you are, you can't just do anything in the spectrum of plastic surgery. You must have had or have credentials in a hospital to do the same procedure in your surgery center in order to document that you're practicing safely. I think that's of the utmost importance. If you're going to let people just do whatever they want to do, you're going to have chaos.
Great. Dr. Abe?
So that means if the surgery center has 10 owner or 10 surgeon on staff, and you find out one of them who's a dermatology and he want to do breast augmentation, what do you tell the center? You have to get him off the...
They're on probation, and shortly they're out. Either get rid of them or they're out.
The same question is, I'm impressed by as a surgeon, that all the data that I might hear, if the medical board requests those data next Monday, are those already in the digital file that you can tell us this 2040 center?
Right, but, we can send data, but I have to say something quite frankly. The medical board has to be equipped to deal with data.
Right.
You can't just get data and go, whoopee, we have a bunch of data. What are you going to do with it? You don't know how to analyze it. You don't have the capability of analyzing it. You need data that means something to you. For example, if somebody had a minor complication, you don't need to know about that. That doesn't mean there was malpractice. You need to know major adverse events, and you need to know is somebody creating hepatitis in a surgery center. There are going to be infections. If somebody gets an infection, that doesn't mean it was because of the surgery center. They go home after surgery. It's outpatient. They show up with an infection 10 days later. Who knows if their dog licked them? So we monitor infections. If we see a problem, we have a whole standard about sterilization, spore testing, down the line. If the medical board and if all of these government agencies start requesting tons of data from everybody, there's going to be a morass of confusion. So I don't recommend you ask for that data. I recommend you trust in the people you already have trusted in to provide safe management of accreditation and give you the data that you should have to continue overseeing the accreditation process.
Well, I'm not asking you to provide all the data, and my point is that we should be able to get data that we want, that the public want to see, put it that way. So I think
Well, it depends on what you mean. First of all, there's peer review safety. Peer review has to be respected. If you want people to honestly report peer review so we can improve healthcare, you can't just lay things out. The public doesn't understand a lot of the data. What are you going to say? If you went out tomorrow and it was reported in the news, my goodness, there were 10 infections in California surgery centers. A lot of people in the public would say, my goodness, 10 infections. That doesn't mean anything. So you have to respect peer review, and you have to request data that is a danger to the public, not just for the publication to everyone. It doesn't serve a good purpose.
I agree with you as a physician surgeon, but we also have to look at from the point of view of the consumer. They don't look at it that way. They rely on us to get meaningful data to them. We can just say, you can understand my data, therefore I'm not giving you.
No, we can give meaningful data, and we do. Do you require specific data? We're able to do that. Whatever the medical board asks of Quadruple ASF, it has been provided in the form of data. Yes, we're capable of doing that.
And we know the data that we are required to collect, so this isn't about violating peer review.
Right, and when you ask for data for us, if we take an action, for example, if we put someone on probation or take an action, you receive documentation immediately of that situation.
So just as an
Dr. Lowe.
example, to put things in perspective for me, how many facilities do you license or do you accredit in California?
282.
282. Have any of them lost their accreditation in the last 5 years?
Yes.
How many?
I don't have the exact
I would have
number.
to look into it and get back to you. I can tell you that there was one facility that had an adverse action that was, they corrected the action, we reported to the medical board, and their adverse action was rescinded.
So you report every facility that has lost their accreditation to the medical board?
We report every facility that just goes on probation.
Is that voluntary or is that mandatory?
I think it's mandatory. The medical board wants to know, it's mandatory that we report any facility. If we sanction a facility, we report it to the medical board. Now, if we review, when somebody has an inspection and we find out they don't have all of their MSR sheets, I don't know if you know what that is, it's a sheet that says the detergent under your sink has a dangerous chemical in it, and you don't have the manufacturer's specifications, do we report that to the medical board? No. Should we? No. Because what does that mean? That means go get that, bring it back, and you'll be okay. But if somebody does something that's egregious and they get a sanction from us, it goes right to the medical board.
Okay.
Just a comment, I think that's the type of information we are looking for rather than just a raw data. Raw data doesn't mean anything. That's your job, you're paid to do that job, so analyze it and give us the information where we can look at and take an action.
Thank you both very much. And IMQ. Ms. Samper and Dr. Silverman.
I meant. Good. Thank you very much. It's a pleasure to be here. And in the interest of time, we will not go through the details. You all have our presentation in front of you. I think you'll find all four organizations do a lot of things very similarly. What I'd like to do is focus on some of the things that we maybe do differently, how we approach it, and certainly answer the questions that you've asked and any other questions you might have. If you have questions historically, I have been involved in ambulatory accreditation in California for 23 years, so I've watched this bill, I've watched it before the bill, and it is on the right track, I think. IMQ's ambulatory first, IMQ is a subsidiary of the California Medical Association. We're a C3 organization that was set up in order to focus exclusively on promoting the quality of care, both through accreditation and education. We have a long history in accreditation, accrediting correctional facilities, participating with the Joint Commission and the State of California in surveying the acute care hospitals in California for accreditation, in accrediting providers of CME and accrediting providers of independent review. Up until 1996, we surveyed ambulatory care facilities on behalf of AAAHC, the facilities in California under the AAAHC standards. In 1996, the IMQ Board of Directors decided to spin off and create our own program. IMQ's board also it's primarily physician board. It is different from the board of the California Medical Association in that it is physicians who are focused exclusively on quality of care and peer review activities. The chairman of our board just stepped down as head of neurosurgery from UC Irvine. Our vice chair is the head of compliance with Kaiser Permanente Northern California. The secretary is a senior researcher and surgeon at UCSF, and our treasurer is the head of the Chinese health plan in San Francisco. We have researchers from RAND, we have a patient safety expert from UCLA. These are all physicians very, very committed to quality of care. They don't get paid a penny for their work there. It's a labor of love and professional commitment. The reason IMQ was set up was to focus on accreditation and care in California. We accredit currently 104 ambulatory facilities in California, which we report to the medical board. Our surveys are all conducted by physicians who practice in ambulatory care settings or have recently practiced in ambulatory settings in California. If we have a 2-surveyor team for a larger facility, the second surveyor may be a non-physician, either a nurse or an administrative person also with expertise in ambulatory health care. We have slightly separate standards for solo and small practices versus larger group practices. Our standards, to be honest, when we formed them, we looked at the terrific standards that the other organizations had. We called through them to try to find what we thought what made the most sense and work to make them as pragmatic as possible. 36 of our standards are the standards required under law from AB 595. In total, we have 175 standards, so we've obviously added significantly to the basic requirements to assure quality care. There gives you the general categories of standards that we have, and the next slide shows you the types of facilities that we accredit. We have 3 levels of accreditation. We have an initial readiness review, which is designed for facilities that are just becoming operational. You've heard about that from another accrediting body. It's very similar. After 6 months, if they get an initial readiness review, we go in for a full accreditation. Any full accreditation can result in either a 1 or a 3-year accreditation, or of course a denial. In order to get a 3-year accreditation, they must be in compliance with all of the standards. If to get a 1-year, they must be in compliance with all of the mandated standards by the state and 95% of the voluntary standards. There are times where we work very closely with facilities up front. So to be fair, when an organization submits an application to us, we review it closely and we call them and we talk with them and we try to identify areas that we feel need improvement and to encourage them to make those improvements and changes before we accredit them. Our goal is to see that the care provided in our facilities is as good as it possibly can be. We also do for-cause surveys. If we have reason to believe there may be a problem in a facility, we may receive a complaint from an employee, from a patient, read about something in the press. We monitor the medical board's website for issues about physicians. Also, all of our accredited facilities must report to us if, for example, physicians take on new procedures from their original procedure list, if they bring on new staff, if they have a change of new physicians that are practicing there, and any of those reports also could trigger a follow-up action from us. Our surveyors are credentialed, carefully screened, and trained in person every year. They're screened carefully for conflict of interest, as well as their skills and expertise in the area. Our surveyors spend a full day at the survey on site for the surveys. We also have them monitor an actual procedure to watch the operation in practice. I'm rolling through this as quickly as I can. Our surveyors are credentialed. We've talked about the different types of survey. If a facility is not accredited, we do notify the board right away. If we do a for-cause survey, when we suspect there's a problem, we go in unannounced. Usually we go in as within a few days of having a suspicion. We investigate it, and then we set it up as quickly as we can. We will determine the findings from that survey within no more than 5 days, and if we terminate accreditation, we notify the medical board immediately. If the committee meets at night, we'll probably tell you the next morning, but certainly within 12 hours. I'm looking through. I think we've covered most of the questions. I'm trying to remember if there were other questions that I can answer.
The process, do you have a standard approach to credentialing and privileging?
Yes. We have a number of standards on credentialing and privileging. We require proctoring. Victoria, do you want to talk about peer review?
So we have physicians provide credentialing and privileging policies and procedures. We also look at their proctoring policies and procedures, and we also have intensive look at their peer review. We expect them to do peer review, depending on the size of the facility, either quarterly or yearly, and to privilege and credential as well. I think the offset, the outside is every 3 years.
One of the things that we focus on when we're doing any of these surveys is looking at the systems that are set up, not the paperwork. So, I mean, the paperwork has to be there, but actually monitoring the systems. And we go in, and our surveyors actually talk through how they've proctored, evidence of proctoring, how they've credentialed, and what evidence they have. For example, if you have a physician that has been out of training for some period of time and is doing a new procedure, obviously didn't learn that procedure in training, they really drill down about how they determine that that physician is qualified, how the surgical skills are comparable, how many view documentation of the proctoring, the number of proctoring, and if there's any question, we'll send somebody in to actually view that procedure being done.
Mr. Serrano-Sul, you want to ask your question?
Oh, your question. Wait,
You
I
know
can
my
answer that.
question, right?
I know your question. I was paying attention.
Thank you. No. So you have about 124.
104.
Okay,
And we believe that we've given you all the information you need, with the exception of some of the owners. You required addresses for those owners, and we have addresses for the facilities, not necessarily every individual owner. We've been, and in fairness, when we met with the staff of the medical board and all the accrediting agencies last fall, I think our understanding was, the agreement was that we would begin to collect the addresses for every physician as they submitted new applications, and I know that that's what a number of us are doing. We certainly, we hear that you want it more rapidly, and we're in the process of collecting it. It would be helpful to know where there's gaps, but we can get that to you very quickly.
The other agency sent a letter and expect to have the information in 5 days.
Well, we can send an email and get it to you probably within 5 days also, but yeah, but it's I don't think there's a lot of gaps in our group, to be honest.
Thank you.
Yes.
For the new facility, how do you deal with the proctoring? For the new
facility,
facilities?
on an IRR, the proctoring issue that you're looking, you want to address that?
The proctoring issue comes if they are not practicing with, they're not doing procedures that they have already been privileged for in an accredited acute care setting or an accredited facility where there's no conflict of interest. So there are standards that we allow them to match, for example. So you can give privileges based on privileges that they have at a hospital or acute care setting. They can grant privileges based on privileges that they have at other ambulatory surgery centers where they do not have a conflict of interest, i.e. ownership or family relations and things like that. If a procedure that they are granting a privilege for doesn't fall under those categories, then we're going to say, okay, show us your training, your hands-on training, your proctoring for the procedure that you're going to do. That's the way we deal with proctoring. Does that answer your question?
Yes.
Anything else? Thank you very much.
Just, Ms. Silverman, how often do you do surprise surveys? Or any reason, and if you see something, do you immediately report to medical board?
If we see something, we look into it first. We don't necessarily do a survey. We've had situations where you get a complaint from a disgruntled employee, and we certainly investigate it immediately, and you start drilling down, and it looks like there's really not much credibility to it. But if we have even the remote possibility that there's something of concern, we go in and we set up a survey within a couple of days. And I would say that happens for us probably a few times a year, to be honest. It doesn't happen frequently, but when it happens, we move very quickly.
And we report immediately.
Yeah.
To the medical board. The other thing we do, and I'm sure the other accreditation agencies do it but haven't mentioned it, is SB 100 requires that now you receive the report and that you identify on the survey report who is responsible for fixing or for the corrective action for whatever standard was missed. And so that is sent up to the medical board. First, we send up the report as is, and as soon as we get it back from the facility with identifying the person who's going to do the corrective action, we send that back up to the medical board. And then when all the corrective actions have been approved by the committee, we once again send up the report saying all the corrective actions have now been completed.
Great. Thank you very much.
Thank you.
Appreciate your time. Okay. Joint Commission.
There's 4, that was 3. It's Joint Commission.
And this is Dr. Berceau and Ms. Hopp, is that right?
Happy, yes.
Hoppy.
Well, as you said, I am Jennifer Hoppy. I'm the Senior Associate Director for State Relations at the Joint Commission, and joining me is Dr. Jim Berceau, who is one of our ambulatory care surveyors. Also, I know since time is of the interest, I'm going to try to glean through some of the less important slides in terms of the background of the Joint Commission's history and mission, and really focus on the issues that you all have been addressing today. So I'm going to provide some background information, and then I'm actually going to turn it over to Dr. Berceau, who explain more in greater detail about the standards and survey process, because I think who better to explain to you how the Joint Commission goes about assessing compliance with our standards than one of our surveyors who does it on a routine basis.
And just as a set point, the number of ambulatory surgery sites that you...
Oh, sure, I will. Oh, certainly. So in terms of in California, for the amount of outpatient settings that we accredit under the that we report to the medical board, it's roughly just over 150 at this time. I think it might be at 160 to date.
Okay, thank you.
All right, so in terms of, as I think most people know the Joint Commission to be one of the, in terms of the leading accrediting body for hospital accreditation throughout the nation, but obviously we also accredit a wide range of other healthcare entities across the healthcare spectrum, ambulatory care providers, ambulatory surgery centers, and office-based surgery practices being one of those. I'm going to skip ahead through. I do think it's important to note that in terms of the Joint Commission's Board of Commissioners, the composition of the disciplines range from physicians to nurses to administrators and patient advocates. And the Joint Commission's corporate members include the American College of Surgeons, the American College of Physicians, the American Dental Association, the American Hospital Association, as well as the American Medical Association. In terms of the goals of the accreditation process, the Joint Commission's focus is really in assessing compliance with our standards through direct survey observations, patient interviews, as well as staff interviews. We focus on the integration of the systems across the organization, and as well as one of our other colleagues had mentioned, one of the real primary focuses and goals of the accreditation process is to provide educative and consultative feedback to the healthcare organization so that they can continue in their pursuit of improving their overall performance activities and overall the healthcare services that they are providing to their patients. Okay, so I'm going to just move this slightly over if you don't mind. In terms of the accreditation process, so once an organization decides to pursue accreditation with the Joint Commission, the first step in that process is the application for survey. The application is designed to collect information on all the sites and services that are under that organization's control, and Joint Commission does accredit organizations as a whole, therefore we do not allow them to pick and choose sites and services to be included. The application information is assessed, and we determine which of the accreditation programs, the applicable manuals, they will be surveyed under. Again, specific to California, we have added a series of questions that are aimed at compliance with Senate Bill 100. First and foremost, we ask the organization to indicate to us that they need to use their accreditation to satisfy the requirements of California law. Following that, they are required to report to us all of the demographic information, such as the name, address, and telephone number, as well as the medical license number for all physicians that have any ownership interest in that outpatient setting that is applying for accreditation. In addition, we require that the organizations disclose to us if the outpatient setting that is applying for accreditation or any of its physician owners have previously been denied accreditation by one of our other approved accrediting bodies. And if that situation should arise, we've also developed a process for requiring the organization to submit a copy of that report that led to the denial to us, and our process would be to assess compliance with those deficient standards from the other accrediting body before we move forward with our accreditation process. One of the other things that is also done at the time of application is the organization must attest that they understand that California law requires us to make both the accreditation report as well as the corrective actions submitted publicly available, and that we will also be providing those reports to the Medical Board of California. We also use an early survey option process for the majority of organizations in California. As Carolyn mentioned earlier, this is a process that's mostly utilized in states where there are law and regulations that require accreditation prior to providing services. So again, that is the same process that's used here. It is a two-part survey process. The first survey, which occurs prior to the organization providing services, uses a limited set of the standards. It focuses on things like environment of care, human resources, the organization's policies and procedures. And the goal of that first survey is to assess the organization's ability to begin effectively providing services to patients. Following that survey, as well as any corrective action that may be needed, an organization will be awarded with a preliminary accreditation decision. And then following that survey, and once they begin providing services, we will come back out, usually in a 4-month time frame, to conduct their full accreditation survey. The accreditation cycle is a 3-year accreditation award, although the Joint Commission does reserve the right to come out and conduct their full survey anywhere between an 18-month window and that 36-month due date. Similar to what the other organizations have reported, we do require organizations to report all changes to us within a 30-day notice. The application must be updated, resubmitted, and then reevaluated to determine if further on-site activities by the Joint Commission are necessary. We have a series of intercycle monitoring requirements that happen throughout the 3-year accreditation cycle. The primary tool being a process for an self-assessment. It's known as the Focus Standards Assessment. Organizations are required to use an online tool to assess themselves against the standards. Any standard that they find themselves to be less than fully compliant with, they're required to do a plan of action and submit that into the Joint Commission, and it is reviewed there. Organizations do this at the 12th and 24-month process of the 36-month cycle. We also do validation surveys. We have 2 forms, both random validation surveys, which is a 5% sample across all of our accreditation programs, for each of the accreditation programs, and we also do evidence of standards compliance validation surveys as well. There is the opportunity for the potential for organizations at any time in the accreditation cycle to undergo a for-cause, or what's commonly known as a complaint survey. In addition, we also conduct extension surveys for any time when an organization begins providing a higher level of service, expands their scope of services to more than 50% of their capacity, or begins offering services at a new location of care. So with that, I am going to turn it over to Dr. Brousseau, who will discuss the standards and survey process.
We'll try to cover this material quickly, but I'm from Kentucky, and we have trouble doing that, actually, when we're from our part of the world. Nevertheless, first, just a few comments about standards development. The Joint Commission develops the standards. It's quite an extensive process and involves participation by many healthcare providers, various experts in the various fields, and it includes government as well, and it's actually welcomed for that participation in the development of those standards. The purpose, or what they're designed for, basically is to set expectations, and that would be both from a minimal and then certainly above minimal expectation for organizations, something to strive for and to be encouraged about. But also it's for us to be able to assess performance. And in the next slide, you will see the accreditation requirements. These are basically the chapters. All the chapters in the manual, all the standards are listed under there. And as a matter of fact, you can go to the homepage on the Joint Commission website and simply select standards and then facts about Joint Commission accreditation standards, and you can see all the detail and all the activity that goes into actually working through and developing those standards. Certainly the California Health and Safety Code 1248.15 for the most part directly is in those standards. But even if one is not, we do have a standard in our manual that talks about compliance with law and regulations. So we have actually another way, even if there is a particular standard that you have that's not clearly stated in our standards. And our expectation of those organizations are in California that they do comply with all of your requirements. The thing I want to mention also that might be of interest to you is what we call a criticality methodology related to the standards. There's a risk and a resolution time frame related to our standards. In other words, they're certainly not all considered to be equal. They're categorized in regard to risk and resolution. We have 4 levels related to that, and we would love to talk to you more about that, but I think you would find it of interest. So all standards really aren't created equally. As important as everything we've talked about is, probably there's certainly not anything any more important than the actual survey itself. And certainly our survey cadre is, I guess for the most part, glad that no one's figured out how to send robots in to do this work yet. It still takes people, it takes trained and professional people to go in and do this. Before I actually talk about that on-site survey process, mention to you that training and education is continuous. It's ongoing. It's all the time. It's not necessarily daily, weekly, monthly. It is all the time, and we have pretty sophisticated approaches to get at that training and education and testing of our survey cadre. There's face-to-face, there's annual conference, there's online, there's preceptorship and mentoring required, there's peer evaluation among ourselves, supervisor observation, and annual reviews, and then the organizations evaluate the cadre as well. There's a lot of review and ongoing evaluation of this cadre. The other thing I will mention as we start talking about the process, and a very important item, and actually we have in our level 1 and 2 in that criticality are somewhat judgment situations. In other words, many of our standards could go to a level that's considered preliminary denial of accreditation. In other words, sometimes something related to credentialing may not seem so severe, sometimes it may seem very severe. We have the ability, and we then actually talk to the staff and the many resources we have at the Joint Commission central office. And those resources are available to us before and during our surveys. Those are physicians, nurses, administrative folks, legal, engineers, and our standards interpretation group. And we're encouraged to use those resources, and they're a terrific resource whenever we're out in the field. So we're not detached or by ourselves out here when we're doing this. There is a great deal of pre-survey preparation that goes into getting ready for the survey, so we have a lot of information provided us, previous survey reports, organization information, lots that we have to digest and review before we go there, and certainly that would include reviewing and being prepared related to California's requirements. The on-site survey process, really, the concept is to evaluate that organization, provide education, good practice guidance, and to help staff continually improve. We try to be positive about that. There is opportunity for consultation and teaching, but I always tell folks, but we're here. The baseline is about accreditation and compliance with the surveys. For us, a major part of that activity is what we call the tracer methodology. And that's a case study approach. Much of that is in our patient tracers. On the slide, you'll see where it says individual tracer. That's in the ambulatory surgery center, that is a patient tracer. And some of our time is in what we call system tracers. So 60% or more of our time is in this approach. Typically, for an ambulatory surgery center, we have 1 or 2 surveyors there for 2 to 4 days. There are rules that justify or help the decision process about how many days and how many surveyors, and it has to do with what's done there, the services provided, how many, those sorts of things. Also, it's a select surveyor group. We have a large number of surveyors in the Joint Commission, but not everyone does the ambulatory surgery centers. We will typically open the survey with an orientation, meet the folks, talk about what we're doing, hear about the place, maybe have a tour, but we quickly try to move to patient schedules and selecting patients for our tracers, because that's where we need to be and where we want to go. It's a pre-A to post-Z process, essentially. In other words, it's not only about what happens with that patient there, it's what's done before and after they leave that we have both standards about and we're interested in how that patient is taken care of. Certainly perioperative, preoperative, and during surgery, all of that we do. And we prefer, and most of the time we're able to at least survey one active patient and someone really there that we basically follow through the whole process with them. In addition to that, of course, that would include sterile processing. We will do that either as part of a patient tracer, or we can actually do it as an infection control system tracer, which again, we do that with medication as well. Follow the whole process of the management of medications, the acquisition, the ordering, the selection, the whole process, administration, monitoring patients. That would be an approach to medication management and a system tracer. We, at other times, and later in the day, obviously in surgery centers, the busy time for surgery, the busiest times usually in the mornings, early. Later in the day, then we go through perhaps the system tracers. We then can do other things like environment of care and the data review session, quality management session that we will always do with those organizations. But essentially with that patient tracer activity, as we follow all the care and the activities of all the people involved, nurses, techs, doctors, everyone, the communications, the record keeping, we review all of that and are basically watching and seeing how all these things are done. That includes following the procedure through in the procedure room of the OR. So we then can cover our standards in patient care, rights of patients and staff, records, environment of care, infection control, medication management. We cover most of those things during those tracers. And most of the time we are able to do more than one of those tracers as well. So that's a critical part of our process. Other things that we do, and I already mentioned, if you go to the next slide, the one I wanted just to briefly mention to you is our approach to privileging. We actually have two processes related to competency. We have a privileging approach that we review, and then we have what we typically often call HR, because it's for the staff that doesn't require privileging. They're both quite detailed and involved. For example, and we have to look at the actual file, but we'll start off talking about their policies and procedures, their process for credentialing, the time frame for doing that, and actually the scope of what they allow people to do in their organization. Then we can move to all the things that require, some of them straightforward and simple, government photo identification, verification, the training, and all of these things are primary source. Licensure, the references, recommendations, peer review, both routine and issue related. We want to see that. National Practitioner Data Bank, again, all of this is primary sourced. Their own health statement, and then whatever requirements the organization has for them with regard to health. We'll look at those things to see that they're being managed and taken care of. Then the privileges. We want to see what privileges they've requested. We want to see what privileges they've been granted in the process for doing that, and we want to see how those match their training and their education as well. We'll look at the credentialing committee meeting minutes to see how that functioned and that it happened as well. And then we also review orientation for them related to safety and policies and procedures, infection control, pain management, those items in that practice. For time's sake, I won't go through all the things that we do for other staff or the non-physician staff, but it's very similar in terms of primary base for requirements and background checks and education and licensure and competency and evaluations, job descriptions, orientation, all of those things as well. So those are the things that we do in that critical part of the whole accreditation process related to the survey itself.
All right. So now I wanted to spend a few minutes talking about what happens after the survey. So once Jim and his team leaves the Ambulatory Surgery Center, the organization is left with what is known as a preliminary report of findings. Those findings will then be reviewed by our central office and typically in conjunction with the surveyor to discuss any, if there were any findings that needed to be clarified. The accreditation report is posted to the organization on their extranet site within 10 business days, and organizations are afforded the opportunity to request a clarification of one of those findings. So basically, if they believe they were in compliance at the time of survey, they do have the opportunity to present that information and potentially have a finding removed. The one thing that I just wanted to point out at this point, the accreditation report is final and is posted to the organization at that 10-day mark, but the accreditation decision is not final until any standard that was less than fully compliant at the time of the survey has had corrective actions submitted, been reviewed, and accepted by the Joint Commission. The majority of organizations will have what we call a requirement for improvement, and those, and that might be something you typically more refer to as a deficiency or a citation, but we call those requirements for improvement, and organizations must submit an evidence of standards compliance for all standards that were less than fully compliant. Based on the criticality of the findings, which Jim briefly talked about in terms of whether we have a direct impact standard or an indirect impact standard, their due date, their time frame for submitting that corrective action is within 45 days or 60 days. It is at that time, if an organization submits their corrective action and it is accepted and deemed that they are now in compliance with those standards, that their accreditation decision is then final. It is at that point in the process when the accreditation report as well as the accreditation decision is final that we will provide copies of the report as well as the evidence of standards compliance that has been submitted to us, and it is in a format of what action they took, who did it, what they did, how they did it, and when they were going to do it. And all of that information is provided to the medical board at that time. In terms of the adverse accreditation decisions of the Joint Commission, we do have three primary categories of adverse accreditation decisions. The first one being accreditation with follow-up survey, contingent accreditation, and then preliminary denial of accreditation. There are three different rationales for how organizations can receive one of those adverse accreditation decisions. And the bulk of those are actually when the findings from the survey demonstrate systematic patterns and trends or repeat findings from previous surveys. However, anytime the Joint Commission is making a recommendation for an adverse accreditation decision, that must be presented to a subcommittee of our board. It's known as the Accreditation Committee. They meet 8 times a year throughout the calendar year, and it is only the Accreditation Committee that has the authority to render an adverse accreditation decision. Excuse me. All adverse accreditation decisions are also reported to the medical board. On this slide, you can see excuse me, the continuum of the Joint Commission's accreditation decisions. And it's those three categories in the middle, the yellow, the orange, and the red, that are adverse accreditation decisions. Both the accreditation with follow-up survey, as stated, requires follow-up survey prior to a decision being rendered and moving forward. So before they can come into compliance, we have to go back on site and conduct another survey. It typically occurs within a 2 to 4 month time frame, whereas the contingent accreditation decision is a more severe adverse accreditation category, and that requires a 1-month follow-up survey. Preliminary denials of accreditation, organizations are afforded the opportunity to request an appeal. That is, it has to be done within a 5 business days. And if they do request the appeal, there will be a review hearing panel that is conducted by a member of our board as well as 2 members of the public to review the facts. In the end, though, if an organization should be denied accreditation, that denial would be reported to the medical board. We would also send notification to the organization in their denial letter that California law stipulates that they cannot perform procedures at a higher level of anesthesia unless they obtain accreditation from another source. At this point, too, I want to highlight that all of our accreditation decisions are publicly available on the Joint Commission's website, and all standards that led to an adverse accreditation decision are also publicly displayed with historical reference. One of the other activities that we were asked to highlight was the complaint process, and the Joint Commission does have a extensive Office of Quality Monitoring that does review all complaints submitted to the Joint Commission. Depending on the nature of a complaint, the Joint Commission, depending on the nature of the complaint, we may conduct an on-site survey. We may contact the organization to submit a response related to the complaint. We could incorporate that complaint into their next full survey if their due date is coming up shortly. And then we could also track that complaint if it's something of a low priority incident in terms of trends for patterns and trends of that organization. I'm just going to skip ahead in terms of, you can read the slides on how the Joint Commission prioritizes complaints, but I did want to give Jim an opportunity to talk about the on-site review of complaints as well.
And first, I want to mention that when Jennifer talked about preliminary denial accreditation, what she just talked about was if it comes out of a survey and a survey report. We have the ability on site when we're there and go in for that, what we thought maybe was a regular survey, or if it's related to a complaint, but it can be a regular survey. If we have concerns, we can call the central office, a clinical team is pulled together, and preliminary denial can be enacted immediately, right while we're there. And we'll stick until whatever the situation has been properly reviewed and corrected. But with regard to complaints, you see in the slide there some of the general information with regard to that. But first of all, it's a limited group of surveyors that can even do these particular types of surveys. It takes different training and experience to do this. And the preparation is extensive. There's file and information and planning that goes into this process. The surveyor is sent in. It's an unannounced approach. We're there for one or more days, and we can extend that time as is needed simply by talking with our central office. We introduce the subject with a letter to them. They are not told the specifics of the complaint. They are told generalities of the types of problems that are in the complaint. There's every effort made to protect the complainant, and from that standpoint. Our focus is on the complaint, but typically we'll end up basically going through that tracer process. That's really oftentimes what it takes to really cover patients. We'll ask for a sample of various records. Usually we're able to pull in the record related to the complaint or records, but others around that, and then go through the whole process of the patient tracer. So we're focused on the complaint, but actually we may, and oftentimes in that situation, find other issues as well that then become part of a survey report, which again, you would receive that survey report.
Thank you. Mr. Serrano-Sewell?
Oh, yeah. Thank you. Thank you for the presentation. With regards to getting all the information and being in full compliance in that respect,
yes.
Can you give an estimate of what sort of outstanding?
Certainly. In terms of the data, out of the 150, unfortunately, when the medical board first did their data file load from of all the information for the website, the Joint Commission at that point in time was collecting the information via a manual paper process because our electronic application as well as our data fields internally had not yet been updated with that information. So when we submitted the original data file, the physician owner information was not yet in our system. From that time, since that time, then the medical board has been going through the process of just as we do the notifications every, when the organizations come up for renewal. But at this time, I can, and I'm more than happy to, we have the data all available, and I can pull it and have it resent in a data file for them tomorrow if needed. In terms of how many organizations may not have that information, just as the other organizations explained, we began requiring this on January 2012 forward. While we have gone back to some of the organizations to ask them to also submit that, I know we do have organizations that have not submitted the information, so we would have to kind of go after them as well in terms of trying to collect that data.
Okay, thank you.
Question? Are the physician surveyors on your team licensed physicians in the state of California?
Not all, no.
So does the Joint Commission take positions like the kinds of medications that a facility should or should not use, such as droperidol?
I'm not aware of that.
Does the Joint Commission have any positions on the use of certain types of pharmacologic agents such as droperidol, which is the brand name Anapsine, as an antiemetic?
No, not that I'm aware of.
I believe that the Joint Commission, at least within the last 2 years, was focused on the use of droperidol, which is probably one of the most effective antiemetics. And essentially, there's none of the hospitals that we practice in use it now because the Joint Commission essentially was not going to approve any hospital or accredit these hospitals because they use that drug as an antiemetic because of the theoretical implication of prolonged QT syndrome and causing torsade de pointe and sudden cardiac death. Now, is that...
It's not in the ambulatory program, that's all I can tell you.
Well, I know, but that was a commonly used antiemetic even in outpatient facilities. So you have no position, the Joint Commission has no position officially?
I would have, I don't have that information available, and Jim isn't aware as well, but I can certainly research that with our standards interpretation group when I'm back in the office.
I can answer from UCSD. We allow it to be used. There's a lot of criteria, a lot of restrictions on its use now. My understanding was our P&T committee looked at the medical legal issues and felt that it was, it has a black box warning now. They're concerned about its use, and so put a lot of restrictions. We still can get it, but it's difficult.
So essentially, we can't even get it.
Really can't even.
We can't even get it or use it, and it's clearly one of the most effective antiemetics.
Here, yeah, absolutely.
But I think the bigger question is what effect or how strong is your position on the use of certain medications determinant on California institutions to be able to use what they feel is the appropriate medication? So when you come to, so I don't know what your policies are on that, but
well, in our
it does affect us.
In our program, basically, it's what the institution and what the Pharmacy Therapeutic Committee is recommending. That in the ambulatory program, that's what we go by. Now, if we ran into some where there was some particular medication, some information, something that we became aware of, we would simply talk to the pharmacy and the physicians and the people at the central office. I'm not aware of any list that we have of that nature.
Okay, I thank you, but I think my concern would be is, given that you're doing these evaluations, do you have a blanket pharmacological list of any kind?
No.
That would...
No,
okay.
and that would just be so difficult to do. I mean, that would be that'd be essentially impossible. We have had some things, requirements that got in the National Patient Safety Goal, for example, about potassium being located in patient care units where people were getting killed with that, for example, a few years ago, and that became an issue. But it would be at that level of a National Patient Safety Goal, not that we would present a list of okay-to-use medicines.
Dr.
I mean, it's
so from my standpoint, with regard to the ambulatory program, I'm not familiar with what you're talking about.
I mean, in a sense, I feel like the Joint Commission has impacted my ability to practice medicine, and I think patient protection is also protecting the patients from having access to the right medications. I mean, we use alternative antiemetics, but none of them are nearly as effective as droperidol.
Well, all I can tell you is from the ambulatory program, we have no standard or requirement or like that.
Dr.
Thanks for coming. Really learned a lot. I just want to ask, do most centers get more than one accreditation, or they just get one, be happy, or most of them get 2 or 3?
I think it's usually one.
You should just do
select one organization. But I have done some where there's more than one of these groups has done that. It does happen.
We have a number of facilities that have come to us that as a second accreditation because they felt there was a value added to it that are already accredited by one of the other bodies, so there is some overlap. But it's not mandated at that point, it's purely voluntary.
I see. I just try to do the math. You have 500 and then 300, 100 something. So it takes into those numbers when we do our job here. How do we gather the data, how to classify? That's the reason I asked. Thank you.
Dr. Gnanadevan, did you?
Just a final comment on this entire thing is that all four organizations were started by physicians, the oldest being 1930s from American College of Surgeons and the youngest CMA with the IMQ. So doctors do believe in high quality care. I think safe and high quality care is very important. So whatever you folks can do to help us, I think that's what we appreciate.
And that's actually our major goal. You know, I think someone earlier said that these organizations really started out promoting quality, helping organizations provide quality and that healthcare, and that's why they volunteered to go through this process. The world's changing. For more and more regulatory, more and more states want, somebody to do this, and the Joint Commission is aware of that. We have to go through process change ourselves, and that's happening. I can tell you right now, I'm part of a group that's looking at some ambulatory surgery approach where we might have to change some of our process. I mean, it's not just old instead, and we're going to do it the same way forever. So it's changing.
And can I ask each of you, I think one or two of you mentioned that you require notification if someone has been denied accreditation or had accreditation withheld by another agency. Do you all ask for that?
That was a stipulation in Senate Bill 100.
Okay. Mm-hmm. Okay. And that in itself is not a basis for continued denial?
No, it is not.
Okay.
It is not. But that is a unique process I believe, for all of us in the state of California with outpatient settings. We don't ask that. Again, it began in January 2012.
But it's a good one.
All right. Any other questions from board
Last question. Since probably this is the only time I can have all four agencies here, I just want to learn. There's some issue about the building. I see you guys all this building review and all that. I mean, patient protection, not just like pain and all that. I think finance, etc. too. Are we doing anything as far as like a surgery center charging $80,000 for cystoscopy versus like $2,000? Do you have any say in? I'm just curious.
No.
Do you have, when you look at it, yes.
We review it not in terms of appropriateness of fees, but we do look at charges for to try to get at access the issue of inappropriate procedures. For example, we had a facility that we were surveying where we found a pattern of billing for emergency colonoscopies on Saturdays, and that was obviously quite a red flag, and we uncovered what turned out to be a significant Medicare fraud, and needless to say, didn't accredit them. And so we do look at those things, but not appropriateness of fees per se.
Yeah, we do notice fraud. We're required by CMS to report that.
For a Medicare,
For
again,
Medicare
for a Medicare
purposes.
deemed status
Yeah.
survey, if we're doing that under the auspices of our agreement with CMS. If we're doing an accreditation survey, obviously that would affect the outcome of the accreditation, and if it's in a state where we're reporting, the state would become aware of that. And we have had a similar instance where through evidently an EMR, I just heard this told by one of our surveyors, through an EMR, the organization was always evidently checking off, it had to do with a heart murmur. So they were always getting the high level of reimbursement on everyone they saw, and so they noticed in that way. So it's exactly the same way we would review that.
Thank you.
Great. So if there are no more questions, I want to thank all four of you for your time and attention and for sitting through with us till 6:30 in the evening. Appreciate it very much.
So,
I do want to ask if there are any comments from members of the public. Yes. Please, yeah. You're off the hot seat. You're off the hot seat now.
Hi, Alicia Cole, and I spoke earlier, and some of you were not here. Just to give a quick recap, I'm a survivor of multiple hospital-acquired infections, MRSA, necrotizing fasciitis, sepsis, Pseudomonas. Ended up a 2-day hospital stay turned into 2 months and 6 additional surgeries. And I wanted to share some unique input that I think I have in regards to accreditation, because during my 2-month hospital stay, I was in my facility during a survey by the commissioning by the accreditation agency, and I won't say their name and who they are unless I'm asked, if you want to know, because you are trying to make a decision. So I was interviewed 3 times by that accrediting agency, and there are just some things I'd like to share from my own personal experience that I think, as members of the medical board trying to decide which agency to go with, that no matter what agency you decide on, I think first and foremost should be patient protection and patient information. And I think whatever agency that you decide to go with needs to have a means of public input in their processes, public comment, a way of filing a complaint with that accrediting agency, and then also making sure that the information and the data that they get from their surveys is useful to the public. Data without usefulness is just, it's rhetoric. During the course of my 2-month hospital stay, like I said, I was interviewed 3 times. There was a survey that took place. My hospital never wavered in their rating by their accrediting agency. It never changed. It never went down. And what I see today is the fact that for me, how an accrediting agency handles acute care facilities that they've been surveying for many, many years is going to be a great indicator of what they will do for ASCs. As I said, my hospital's standard never was decreased at all. However, during that same time period, and for a 2-year period, my hospital was cited at the highest level of infection control problems with the Department of Public Health that the law can allow. For 2 years, consistently, they were cited for deficiencies in infection control and not adhering to their own policies and procedures. Now, they almost lost their Medicare funding, which is 40% of their income. And during this same time, they still remained a stellar-rated hospital. They had to hire the firm of Hooper Lundy and whoever to represent them and to do a plan of correction. Additionally, while they were in jeopardy of losing their Medicare funding, they also had an F rating with the Better Business Bureau. So I think it's going to be imperative that whatever agency that you go with definitely is keeping tabs on what is going on, not just within what happens during that survey, but also with what's happening with other governmental agencies as well.
Thank you. And just to be clear, these are all for approved and currently accrediting agencies, so we're not selecting one among the 4.
Okay.
These are all agencies that are doing business in California.
Right. Right, no, I'm aware of that, but I just,
Okay.
I didn't want to mention.
Yeah, no, thank you.
Thank you.
Okay. Before we, did you have a?
I just wanted to reassure her that Health and Safety Code 1248 does require that the facility notify the public within 30 days of the survey that they are going to have a survey so that the public can contact us, and our information is there so that they can contact us. And once we accredit a facility, we send them a certificate of accreditation, but also a public notice posted, where if they have any issues, they can contact us as well. So we do have our information out there when the organization is.
Well, I understand.
And just take, thanks. Take it offline. Thank you. Great. Before we move to agenda item 5 and adjourn the meeting, I want to take this opportunity to recognize a board member who served on this board from 2008 and 2012, Dr. Jorge Carrion, who's sitting in the back of the room. And Dr. Carrion was an incredibly valuable member of this board. He brought his perspective as an obstetrician gynecologist and of the many, many roles he's played in healthcare in this country. We miss him dearly.
Yes. Jorge Carrión.
He served on our Access to Care Committee, our Wellness Committee, our Education Committee, and took a leading role in our cultural and linguistic access standards. He was elected board secretary at our July 2012 meeting, and then we lost him, and we were heartbroken. But he was also very graciously offered and came and helped us at the February summit on a joint summit on appropriate prescribing that we conducted with the pharmacy board. So it's lovely to see you again. Congratulations.
Thank you, Dr. Levar.
And, there you go.
Thank you very much, members of the board. My experience in the medical board has been very grateful to work with such an accomplished people and dedicated people. I gained a tremendous experience in my profession and also in my personal life. As a doctor, I am a very meticulous surgeon. By working in the ward, I became more analytical doctor, and I will call myself super analytical, because working with my peers, we review so many difficult cases, and in the end, we reach an agreement. And in my personal life, I have friends that I'm going to have for life. Thank you.
So I'm going to now move to agenda item number 5, and could I have a motion to adjourn the meeting?
No recess.
We're
going to close
Oh,
session.
sorry, to recess
After
and go
closed
into
session.
closed session, so board members don't go anywhere. And after that, we will resume
unfair.
tomorrow morning at 9 a.m.